Good afternoon, folks. This is the Joint Judiciary Committee special meeting on COVID topics. And we're just about to begin our third topic of the day, which was originally listed as the 12:30 session, review of mortgages, eviction, and forbearance impacts. I trust you all had a good lunch, and we'll promise as best we can to have as much fun this afternoon as we had this morning. That was a spirited discussion, really important topics we dealt with. So I do want to mention that Senator Anselmi Dalton has to excuse herself for a little while around 2 o'clock, and she's not just playing hooky, she's cleared that with us, and she has another legislative duty. Representative Anselmi Dalton, Senator.
Thank you, Chairman, for quiet. Actually, they told me they'd move the meeting to next week for me, so I cleared so I could stay on this.
Oh, okay.
Thank you.
Well, good. Glad to have you. So we have some of our witnesses in the room. We'll be seeing you in a few moments. We'll remind you when it's your turn to speak, if you'll give your name and your affiliation for the sake of the record and for the viewing public, and also address your comments through the chair. We'll look forward to hearing what you have to say. So to begin the afternoon session, we have the introduction of the topic from Mr. Hopkinson of the Legislative Service Office. Mr. Hopkinson.
Thank you, Mr. Chairman. As you indicated, this is topic number 3, review of mortgages, eviction, and forbearance impact on landlords for support of poor, Amendment 4, or constitutional amendment. In the interest of time, I will err on the side of brevity and, of course, stand for any questions at the end. Just to jump right in looking at legislation that has recently been enacted dealing with these topics, we'll start with the CARES Act. That act instituted a moratorium on foreclosures for all mortgages guaranteed by the federal government. A borrower experiencing financial hardship may request a forbearance for up to 180 days, which may be extended upon the request for another 180 days. Currently, the moratorium on foreclosures is set to will expire June 30th. At the end of any moratorium or forbearance, the money would still be owed, but the borrower typically will be able to work out a payment plan through the servicer and the backing agency. A moratorium on evictions for tenants in homes where the landlord has a federally guaranteed mortgage was put in place for March 27th and is currently set to expire July 25th. That moratorium on evictions for tenants applies to covered property, and that's defined as that property participates in a covered housing program, which includes, as defined by the Violence Against Women Act, participates in the Rural Housing Voucher Program under Section 542 of the Housing Act of 1949, has a federally backed mortgage loan, or has a federally backed multifamily mortgage. And the landlord following the moratorium must give 30 days notice of an intent to evict if that still is their intention. The legislature did just recently pass in the special session Senate File 1002. That requires the Wyoming Community Development Authority to establish a temporary program for the payment of rent and the avoidance of evictions for persons impacted by the COVID-19 coronavirus pandemic. The program provides payment to an applicant who is the owner of property rented or leased to a residential tenant and who has lost 25% or more of the rental income generated by the property as a result of the COVID pandemic. The awards provide monthly payments in the amount of the lost monthly rental income. The landlord is required to certify that the award is used to provide housing to a household where one or more members has experienced lost income due to COVID and are unable to pay rent. It's conditioned on the landlord not evicting the tenant for failure to pay rent and not charging rent or not charging more than the difference in lost rent compared to the actual rent charged as of March 1st, 2020. The program payments would continue until the governor determines otherwise, or December 31st, 2020, whichever is sooner. Senate File 1002 also allowed for an alternative or additional program where the governor, through the Wyoming Community Development Association, can establish a temporary program to provide rent, security deposit, mortgage payment, and hazard insurance assistance for Wyoming residents at risk of losing their homes. It ties the program to the principles and concepts of the Emergency Housing Assistance Program administered by the Montana Department of Commerce. The program limits awards to residents in need who have suffered loss of employment or substantial income due to COVID and who own an occupied mortgaged residential property or are the tenants of rented or leased residential property. The program deducts from any award any monetary assistance provided to a mortgage holder or property owner as a result of COVID that accrues to the benefit of the resident. Establishes eligibility criteria, including income thresholds and mandatory co-payment obligations. Payments again continue until the governor says otherwise, or December 21st, or 31st, excuse me, 2020. There are several Wyoming constitutional provisions for the committee to keep in mind during this discussion. Those are spelled out or written out in the memorandum provided. And just briefly, Article 3, Section 36 does prohibit appropriations to be made for charitable, industrial, educational, or benevolent purposes to any purpose or corporation not under the state's absolute control. Article 16, Section 6 prohibits the state from loaning or giving its credit or making donations to or in aid of any individual, association, or corporation, except for necessary support of the poor. Article 16, Section 12, the Economic Development Loan Fund provides some additional exceptions to that. And additionally, all appropriations made must be made for a public purpose. It is not clear at this point to what extent these constitutional provisions would apply to the federal CARES Act funds that the state has received. And that's still kind of an ongoing debate. But with that said, I'll stand for any questions that any member of the committee may have.
Thank you, Mr. Hopkinson. Any questions? Representative Washit?
Thank you, Mr. Chairman. The letter that was attached with the vetoes and with the signing of prior legislation during a special session, the governor's office argued that the CARES Act money was not affected by these constitutional proceedings. Is there precedence? Is there any background where I don't know how to say this, but it seems risky to say that flow through money from the federal government does not have to be appropriated in accordance with the state constitution. Is there case law precedence? I understand that there's ongoing debate, but where are we at with that debate?
Mr. Hopkinson.
Thank you, Mr. Chairman. Representative Washit, I'm not aware of any particular recent developments. I don't believe there's any Wyoming case law that is directly on point. There certainly are, I think, good arguments to be made that it should be subject to legislative appropriation process. But I don't have at this point anything much more specific or explicit than that. There are other states that have found that unmatched federal funds, well, there's at least one state court that's held when federal funds are received in the state's treasury, at least one provision of the state's constitution requiring appropriation applies. So there are other states that have found that they do apply. There are some states that have found that they are not subject to legislative appropriation. And at least I believe in Missouri, their constitution specifically allows for those to be distributed without legislative oversight. And that's the best information I can provide at this particular point in time. I would certainly be happy to continue to dig into this matter and provide any updated information to the committee as available.
Representative Washit, anything else?
Thank you, Mr. Chairman. No, we'll leave it at that.
Representative Stith.
Mr. Chairman, thank you. Mr. Hopkinson, part of the special section Senate File 1002 was mandatory for the Wyoming Community Development Authority, and a part of it was permissive. With respect to the permissive aspect of establishing the payment for people's mortgages, for example, has the governor and the WCDA actually started to implement that, or do you know?
I honestly don't know.
Okay, any further questions for Mr. Hopkinson?
Mr. Chairman,
Mr. Fuller.
just Representative Stiff, to your question, I believe the WCDA is here and can answer that, but I think the application came online either yesterday or today, but they can speak more to that.
Okay. Anything else? Anybody we would like to ask Mr. Hopkinson? All right, blue hands down, and we'll move to our first witness. And forgive me if I mispronounce your name, but Miss Gliam?
That's correct. My name is Julie Glean. I'm the director of the Cheyenne Landlords Association.
And Miss Gliam, could you, yes, your name and your affiliation. Thank you.
My name is Julie Glean. I am the director of the Cheyenne Landlords Association. We've been around for almost 25 years. Our purpose is to provide landlords with education and training on areas such as best practices, teaching them what they can and can't do in the line of renting, and making them better landlords. Even though we call ourselves the Cheyenne Landlords Association, our membership is actually statewide. We have over 300 members, and we have over 10,000 rentals in Wyoming. The membership is free to the landlords. We do this by bringing in speakers from a variety of fields such as law enforcement, insurance, legal, and utilities, just to name a few. Because of this, we've become a clearinghouse of problems that surround the rental field. Landlords call with problems they are having with tenants. Tenants call with problems they're having with landlords. We also hear updates on what is going on in the world of rentals in Wyoming. When COVID started on March 15th, there was a universal freeze of rents and utilities. Some people actually benefited from the virus in that they were receiving more from unemployment than they did from their regular pay. And they also received unexpected stimulus checks from the federal government. Some people were harmed significantly. They didn't qualify or were not able to get unemployment. Their stimulus checks didn't arrive. Tenants stopped paying rent, and landlords had a difficult time getting assistance when rents weren't paid. We have some units in Fremont County that were 90% occupancy that are now struggling to keep a 10% occupancy. That by far is the hardest hit county in the state. Some landlords have as much as 75% of their rents not paid. When COVID hit back in March, our first order of business was we had to deal with the April rents. What was going to happen? Very quickly realizing that many rents were not going to get paid, we immediately set to work on getting a lease addendum drafted that landlords could use to negotiate the April rents with tenants. This has been sent to members of this committee via email this morning. With the very valuable assistance of Bruce Asay of ALG Law in Cheyenne, we drafted an addendum that was not only good for April rents, but could be used for May and June rents. And frankly, it could be used for future rents if necessary. Although the addendum, once we did this addendum, we realized it could be used for April, May, and June. We did become aware that if it went into July rents, we were going to have big problems because at this point, landlords would be without 4 months worth of rent on each unit potentially. We were encouraging landlords to work out repayments of their rents, of unpaid rents with tenants, and that this would go through February 28th of 2021. We picked that date because it was under the assumption that tenants would now be receiving their 2020 tax refunds, and many of them would already have those refunds in the mail. We had some landlords, usually from larger corporations, that really stepped up and gave a generous assistance to tenants that were having problems. We had many landlords that worked out rent with the tenants. Unfortunately, we had a handful of landlords that for whatever reason was going to push forward toward eviction because rents didn't get paid. At this same time, the federal government came out with moratorium on subsidized rentals that you just heard about. That would include stuff here like the Cheyenne Housing Vouchers, which is also a statewide program, mortgages backed by the federal government, and tax credit properties. These units are under moratorium until July 25th of 2020. That means essentially that landlords can do absolutely nothing to collect rents on those type of properties. That doesn't put a moratorium on those property though for all evictions. It doesn't deal with evictions when there's a violation of the rules, which is something different from the financial piece. One thing that was clear through the moratorium only included financial issues and not the financial lease or non-financial lease obligations. It is imperative that we never have a moratorium on evictions, which are due to non-financial lease violations. This would include stuff like significant damage to a unit, one tenant interfering with the employment or ability to work of another tenant. The next issue was the local circuit courts. They're typically where the FEDs get filed or the evictions. They stopped doing all hearings. We were eventually able to start getting telephonic hearings, but they were very limited and with a lot of strings attached. Prior to COVID, the eviction process started with a notice to quit, which could be posted to the door. Now with COVID, the notices to quit had to be signed by the tenant. If the tenant refused to sign, the landlord had to wait out COVID until the court opened its doors for in-person hearings again, which could be months away. The telephonic hearings had some procedural issues because of COVID, mostly how to exchange evidence. But other than that, they proceeded in the same manner as before COVID. They were just telephonic. Then we ran into the issue with writ of restitutions. The only person, according to state statute, that can receive a writ of restitution is the local sheriff's department, and he refused. It took us filing an order to show cause or contempt of court against the sheriff's department to get these served. Without the writ of restitution being served, the entire eviction action was an exercise in judicial frustration. The contempt of court action was an expense incurred by the landlord to pay an attorney, which ultimately will be passed on to a tenant and was entirely unnecessary. It is important that the legislature make it very clear that when it creates any type of statute, that a sheriff's department cannot turn around and that the sheriff's department around the state must follow the intention of the legislature and not cherry pick which statutes they're going to follow and which ones they were going to ignore. Because very much during COVID, they chose to ignore the writ of restitutions. Evictions are down almost 70% statewide. Although they are going to pick up, and they are picking up as we speak, and we expect a very large spike in evictions in July and August when the courts reopen for full service and moratoriums are lifted. The evictions will start first on the properties that do not have any type of federal funding and they're not tax credit properties. But by the end of August, all properties will be involved. Many of the evictions that have been occurring are tenants that routinely abuse the system. They are tenants that routinely use excuses to not pay rent and violate any and all provisions of the lease. I want to share just a couple of these, the rules violations that we've dealt with. We had a case on the south side. A tenant was stealing the property of the neighbors. She was spitting on the neighbors and then sharing with them that she had COVID and just gave it to them. She assaulted the landlord. There was a case in the Cheyenne newspaper about some children that threw a black cat off the third floor of an apartment. Prior to that, that same apartment was being evicted for drug use. They were being evicted because they had multiple squatters in the apartment. When we say 2-bedroom apartment to you, many of you instantly think bedroom. These people chose to use one of their walk-in closets as a 3rd bedroom. At one time, they had almost 20 people squatting there in a 2-bedroom apartment. We had another person that was licking the doors of the neighbors and telling the neighbors they had COVID. This was his way of saying, don't go to work, don't go to the grocery stores. I just looked your doors, you can't touch them. We had a fourth person that chose anytime a neighbor wanted to come out the door to sick his pit bull on them. It was his way of saying, you need to stay home. Those are some of the non-financial issues we were dealing with. Those have to be going forward at all times. We can't have just a stop to those because people have to be held accountable for their actions. Not one of those incidents I just described had anything to do with money. There is a new program called WEHAP, W-E-E-H-A-P, which is from the WCDA program. This program is for tenants only, not the landlords. Its application came down today. Landlords can encourage tenants to apply, but they cannot do it for them. Some tenants will not apply because they have heard there's a moratorium on rents, which they've interpreted to mean they don't have to pay rent ever. The WEHAP program, one of its faults that we had discovered, it doesn't cover utilities. This brings us to the unpaid utilities. Starting on March 15th, gas, water, and electric stopped shutting off. So those bills started running up. We expect those bills have been increasing to the tune of $300 to $500 per month, depending on the size of the unit. There's no way for landlords to get assistance with these bills. Why do we make such a big deal of these bills? Well, first of all, let's talk gas and electric. Landlords have landlord agreements on gas and electric. Essentially, if a bill doesn't get paid and goes to shut off, the bill converts over to the landlord if they have a landlord agreement. So we've immediately advised all landlords in Cheyenne, cancel your landlord agreement. They cannot absorb these large bills that have been accumulated since March 15th, which could be at this time as much as $1,000 per unit. And keep in mind at the same time, these bills are higher than usual because we have kids being educated out of the house. We have people working out of their homes. And when COVID started on March 15th, Wyoming was still in the middle of the winter months. And then, there was one time I was approached by legislatures about possibly funding LEAP. That is a possibility, but if you're going to fund LEAP, you've got to change some of its terms because LEAP only works from October to end of March. This isn't the time where they normally pay utility bills anyway. Then there's the water bill. The water bills are different because Wyoming statute currently says that water bills follow the landowners. So even if there's a landlord agreement or not, the water bills are coming back to the landlords. The landlords are completely without any control over water bills or its usage or whether it stays on or goes off. But they are ultimately responsible for the bill itself. A couple of years ago, we brought a water bill to the Wyoming legislature. The purpose of this bill was to stop municipalities from collecting water bills from the landlords. Our hope, our goal for the bill was that the cities would start collecting a deposit when they set up water service, and that deposit would ultimately cover any unpaid water bill. The landlord would no longer be responsible for it. But it's not just a landlord problem. The municipalities have an economic burden as well. The way we're currently doing it, the city of Cheyenne pays the Board of Public Utility, which is our water board, the sum of $50,000 to $250,000 per year. And they've been doing this for as long as I've been paying attention, which is 10 years, to cover unpaid water bills. So these are water bills that are going to property that they can't find the owners of the property. By collecting a deposit with time, that sum will go down as well. So it won't just be a landlord problem, it's a city problem as well. And we just feel that it would be more economically sound to start collecting deposits in the same manner that the gas and electric companies collect deposits when they set up services. As there is an initial economic cost to the water companies because they will have to set up their accounting procedures, but the long-term savings, it far outweighs any cost of initially setting up an accounting procedure. Representative Blackburn has agreed to re-sponsor this bill again in 2021 And we are asking for your sponsorship of the bill, or at least your support of this bill to get it passed. Then there's one last thing. And as I listened to y'all this morning, I thought, oh, do I bring this up or not? You all brought up liability, and you were talking about liability of passing on smallpox and stuff like that. We are aware that we have been told that there's a possibility that coronavirus can be transferred through systems such as air conditioning, heating, common plumbing systems. In your 2plexes, 4plexes, 8plexes, they all share common systems. We know in the past that there have been some things that have been passed through these systems. Where is the landlord's liability if COVID gets passed from one tenant to the next through those systems? Keep in mind, we're not allowed under fair housing or HIPAA to ask about medical problems, but we should not also be liable if it accidentally gets passed. I will stand for questions.
Thank you, Ms. Gleam, for your presentation. Representative Burlingame has a question for you. Representative Burlingame.
I'll wait. It's so far past that my thoughts are not gathered. Sorry.
Okay, I'm sorry for that. Representative Washit.
Thank you, Mr. Chairman. Ms. Gleam, thank you for being with us this afternoon. I want to go back to this water bill. I remember it, and I think it was in the 2019 session that Representative Blackburn brought that water bill. What's the potential loss to a landlord if a water bill accumulates over time before someone is actually evicted? Could that be a sizable amount of money?
Ms. Gleam?
I think on average about $400 or $500 per tenant, but we have seen it get up to the $600 and $800 range. And, you know, that is barely covered. They leave a damage deposit behind. The tenants do 1 month damage deposit. Those damage deposits barely cover actual damage. They don't cover the utility bills. It's just not enough money to cover both.
Thank you.
Back to Representative Burlingame.
Thank you, Mr. Chairman. I apologize. Thank you, Ms. Gleam, for coming and talking to us today. My question was about when you started, you told us of a sheriff, but if you said which county, I didn't catch it, who refused to follow through on an eviction order, and the landlord needed to go to the courts to seek redress. Can you tell us why they refused? What their rationale was, and maybe what county that was in?
It's Laramie County. The county is Laramie. And at the time they stopped serving all legal papers, which included writs of restitution. Well, you know, most legal papers, somebody can go and have a private process server serve it. But anytime there's a need to take over the possession of property or person, that must be done by the sheriff's department. And so, he had just did a blanket order, we're not serving anything legal, but that included these things where he's the only person that can serve them. And so if he wants to come down with that order, he's got to limit it.
Representative Burlingame.
Thank you, Mr. Chairman. Thank you, Ms. Gleam. I should have been more specific. Did the sheriff in that instance feel like he was not empowered by the current legislation, or that he was disempowered by our special COVID-19 bills to not do it? And I mean, obviously we can pick up the phone and go directly to the sheriff for this information. If it's outside your purview, that's fine. But just to your knowledge, did he feel like he was not empowered to do that, or would have put himself in jeopardy had he followed through on it?
It was our understanding he was not doing it for fear that his officers would get COVID. And it was that type of protection, but nothing, we were not under any purview of anything other than that.
Thank you.
Any other questions? Representative Stith, you had your hand up at one point.
Mr. Chairman, thanks. Ms. Gleam, is it your understanding that that issue with the sheriff has now been resolved?
Eventually, we did one We won the first order to show cause. He was willing to do that case. He threatened not to do it on the second one. We told him, we'll be back if you don't. And so he has agreed now to do writs of restitution. And since then, he's opened up for all civil process. So we've resolved it since then.
Madam Co-Chairman?
Thank you, Mr. Co-Chair. Did you, Ms. Gleam, thank you. Just for my own clarification here, and as we hear earlier this afternoon from the chiefs and sheriffs representative, did you do the order to show cause on the sheriff, asking him to show cause to the court why his office wouldn't issue those writs of execution?
Yes.
Ms. Gleam?
Yes, we did do there. We did serve that on the sheriff, and there was a full hearing in the circuit court here, and it was ruled in the landlord's favor.
Against the sheriff?
Against the sheriff.
Yeah, okay, interesting, thank you.
Representative Burlingame? Okay. Any further blue hands? Any more questions for Ms. Gleam? That was good testimony, gave us a lot of insight, didn't make us want to go out and buy an 8-plex. Tell you, there sounds like lots going on in the world of landlords.
Yes,
Well, if you're done,
I
you're
am.
completed. Okay, let's move on to hear from the WCDA. Mr. Hoversland, is it?
Yes.
If you introduce yourself to the group and let us know how you can help us.
Yes, I'm Scott Hoversland, the Executive Director of the Wyoming Community Development Authority. And as was said before, we were authorized under Senate File 1002 to start a program in addition or as an alternative to the landlord payments. And what we did was get a program up and running that is called the Wyoming Emergency Housing Assistance Program. And as was noted earlier, that went live today at 8 o'clock this morning. And as of I can look on my system. As of now, we have 8 completed applications in, and as many as 40 others that are in the process. It's an online application system, so it's available for mortgage payments, rental payments, rent deposits if somebody is without a home and needs to apply for a rental unit. It can cover the deposits, and then hazard insurance if people have a home and they don't pay that in their mortgage payment, they can have hazard insurance covered by that. Under the program, there's a maximum payment per month of $2,000 per month that we'll cover. We ask for a copay if the borrower or renter has the ability for a copay based on 30% of their current monthly gross income. So it's based on their current gross income. It's not the pre-COVID income, it's what they're making now. In that we count the $600 unemployment, that additional unemployment. If they get that, that counts towards their current income. The income limit is at $20,833 per month, so that works out to be roughly $250,000 a year. And there, when we listened to the special session, I think there was a lot of talk about being able to cover people around the state. And if you had a doctor that maybe did elective surgery and their payment, on their house was based on prior to that, and they lost income, we don't want to lose those people out of state or those types of things. So they would still be covered, but they're limited still to that $2,000. And they have to make a copay of 30% of their current gross monthly income. Like I said, that program was released this morning at 8 o'clock, and right now we have we're at 8 completed applications and probably about 40 to 50 more that are in process. So I think there's been in the last 2 weeks a lot of calls and interest from people around the state of when that would be out. So we wanted to get that out, but we wanted to make sure our process was ready to go and we wouldn't all of a sudden overload a system and crash it. So that went live this morning and it seems to be working fairly good. We've got a few people reviewing those applications already and our rules were published, or we sent them in, our emergency rules. The Wyoming Community Development Authority Board approved those last Friday, the 29th. They got filed with the Secretary of State later that day, and the governor signed them on Monday. So the emergency rules are in place and filed with the Secretary of State's office. The other part that I think David with LSO talked about was the forbearance, the forbearances on mortgages that are federally backed mortgages. And as of the end of May, for the mortgages that WCDA services, we service approximately 14,500 mortgages in the state of Wyoming, and at 14,800 actually. And as of the end of May, we had 580 of those mortgages that were in a forbearance program, and that works out to about 3.9% of our portfolio. So that's a protection that's provided for those individuals that have a federally backed or federally insured or guaranteed mortgage. So I don't have numbers for statewide, but as far as our portfolio, that's what that's looking like right now. So hopefully, I heard Mrs. Gleam's concerns about not implementing the first portion of that legislation, and that is we can watch things as they go, but qualifying individuals for rental assistance and mortgage assistance is how many programs are set up, and I think the easiest and quickest way for us to get that support out there. But I have also had calls from landlords that said, well, that may not do me any good. I have 6 renters, 3 of those have COVID related things, and they're the ones that are talking to me. There's 3 others that I have that kind of just, shunned me and said, well, you can't kick me out right now. And I couldn't say that for sure. It kind of depends on how the rental place property is financed. If it's financed with federal funds, then that is true. But if it's not, if it's units that the landlord has owned and owns outright, then that eviction moratorium doesn't necessarily, have that federal backing. The problem that individual landlord told me about that is then it will cost him about a minimum of $600 to file the eviction process and get through that. And so that ends up costing him additional money. So that's pretty much it for what I have. And if I'll answer any questions.
Thank you, Mr. Overland. Are there any questions? Any questions? Okay, I'm not seeing any, but if you could stick around, we might have something for you before we're through.
Okay, thank you.
Let's move to Representative Duncan. Welcome, Representative.
Hello.
And we know you can introduce yourself in a moment. We know you were in the thick of this discussion in the House floor a couple of weeks ago. So we wanted to hear from you today and see what you were thinking now with this thing just rolling out today.
Yes. So Representative Shelley Duncan from Torrington, Wyoming. And I did email all of you guys, and I'm sorry it was last minute. I actually had no idea I was going to testify. And so I just kind of threw something together last minute. As many of you know, but the public doesn't necessarily know, that I am a realtor. I'll give you a quick background. I've been a realtor since 2005. worked my way up as in leadership, and from the local level on up to the state level, and now at the national level. So I was 2017, I was the state president, and now I am the vice chairman. Next year, I'll be the chairman of Housing Opportunities. And Housing Opportunities Committee actually goes over affordable housing and issues for housing for the whole nation. So I'm very thick in the middle of this issue. So what I'll do is, if you will indulge me, I don't know if I have the ability to share my screen. So if LSO will let me know if I can do that, or if
Representative Duncan, you
yes,
have the ability to share your screen.
perfect. So let me go in and see if I can share, and let me do my from the start. Can you see? Can you see?
I can't yet.
It's trying. Can you see yet? Let me know if you guys can see yet.
Okay, no, we cannot.
Not sure why it's not sharing. Go back to Zoom, see if it's screen share again, desktop. For some reason, it's wanting to change my security preferences. So I guess, LSO, do you guys have access to my presentation?
Representative Duncan, I have access to it and I can certainly share it if you'd like, if you make sure to walk me through.
I'll tell you next slide. Will that work?
Perfect.
Okay, so let's start with the first slide. And I'll follow along with you. I'm ready when you're ready. Sorry about that delay.
Okay,
I'm not seeing anything, so you tell me when you.
we're not seeing anything yet either, Representative, so we're just in wait mode.
Okay. Oh, there you go.
There we
Perfect.
go.
All right, so you can skip to the next slide. And the next one. So federally backed mortgages, if you have a federally backed mortgage, which is the FHA, Veterans Administration, VA loans, USDA, which is United States Department of Agriculture, Fannie Mae, Freddie Mac, your loan servicer must offer you a deferred reduced mortgage payment called a forbearance. Up to 6 months. This means that you don't have to pay your mortgage and you won't be charged late fee penalties or interest while you can't pay. Loan servicers for FHA, Freddie, Fannie, they must provide an additional 6 months of forbearance if you request it. Next slide, please. So federal officials have imposed a nationwide halt to foreclosures and evictions for more than 36 million Americans with home mortgages backed by the FHA, Fannie Mae, and Freddie Mac. The moratorium only affects borrowers with mortgages that were backed by the Freddie and the Fannie, FHA, VA, and rural housing services through the USDA. So this doesn't apply to roughly 35% of mortgages held in bank portfolios and private label securities, but some individual lenders were offering release. So when I was talking on the House floor, so for those senators that didn't have the benefit of the debate in the special session, what that means is if you have an in-house loan or a contract for deed, you don't have the benefit of having this moratorium. So that would be a lot of times your people who are necessarily are a lower credit score, a higher risk, or even a unique situation, and sometimes even your commercial lenders or your commercial borrower. So those are some of those that aren't protected in these 35%. Sometimes even your commercial property or even your conventional loans. A lot of your conventional loans, yes, they are government backed, but a lot of them aren't. So you've got a whole segment of which is 35%, who are not backed by the government. So some cities, counties, and states, including Delaware, Indiana, Kansas, Louisiana, New Hampshire, North Carolina, and Texas, they've actually placed moratoriums on these foreclosures. Next slide, please. So as a reminder, the CARES Act forbids lenders from dinging your credit score for missed payments on federally backed mortgages, student loans during this forbearance period. So the federal government also encouraged private lenders to suspend reporting late payments on your eligible mortgages. But that doesn't mean that they're required, that they must, but it does, you know, they're encouraging you not to. Next slide, please. So the National Association of Realtors go back. There you go. The National Association of Realtors estimated that how many people may struggle to pay their mortgage payment or rent because they lost their job in the last 5 weeks. To do so, they compared the monthly housing costs with the unemployment benefits provided by their state and federal government. First of all, the American Community Survey provides individual record information on housing costs. Thus, we were able to estimate how much every household spends on housing. At the same time, under the CARES Act, weekly unemployment benefits consist of two parts: the benefit amount provided by each state and the addition of the $600 a week from the federal pandemic unemployment compensation. After adding these two types of unemployment benefits, we're able to compute the average weekly unemployment benefit for every state. Nationwide, the average weekly unemployment benefit is nearly $980, which is $3,910 per month. However, people typically spend 30% of their gross income on housing. Thus, if the mortgage payment or rent is higher than $1,170, these people who lost their job will struggle to pay their mortgage or their rent. Nationwide, while more than 26 million people lost their jobs, it is estimated that 11 million people struggle to pay their mortgage payment or their rent. These people represent nearly 42% of the households across the country. At the state level, the District of Columbia, California, and Maryland had the most people with a payment of rent higher than the cost then that they can cover using their unemployment benefits, or 30% for housing. Next slide, please. In Wyoming, go ahead and, there you go. In Wyoming, 24,817 people lost their job in the last 5 weeks. In the last 5 weeks, 30.5% of them struggle to pay their mortgage or rent. This means that 7,570 of them have a mortgage payment or rent higher than 1,222, 30% of their unemployment benefits. The average unemployment benefit monthly was $4,073. The amount of housing monthly was $1,222. So the share of owners struggling is 38.7%, and the owners struggling converts to 6,745 people. So struggling with their payment or their rent is higher than that of the cost that they can cover using their 30% of their unemployment benefits for housing costs. Next slide, please. The CFPB defines that a forbearance is when your mortgage servicer or lender allows you to temporarily pay your mortgage at a lower payment or pause paying your mortgage. You will have to pay that payment reduction or the paused payments back later. Next slide. On May 13th, 2020, the FHFA announced a payment deferral as a new payment option. So for homeowners in forbearance due to the COVID-19 payment deferral, it allows them to make up missed forbearance payments when they sell their home or refinance. So that's a big deal. So I want to restate that for you. What that means is, rather than having a balloon payment, as it was stated in the an email that correspondence that went back and forth between me and the governor's office and with WCDA, me and the governor's office about my third reading amendment, was that their fear was that we were going to have a balloon payment for those that were having a forbearance. The option of removing that that part in this bill was that we were going to burden our homeowners in Wyoming by removing the lenders, or the forbearance part for all homeowners, is because of the government financed part, is because we were going to put this burden on them. But pay attention to this. We have a new option here where they don't have to pay it back until they refinance or until they sell their property. The other part is that it is the option when they make they talk to their lender and they renegotiate with their lender. So it could either be tacked on to the end of their loan, it could be a repayment option, it could be many different things. So it could be a repayment solution responsibly simplifies the option for the homeowner while providing an additional tool for mortgage servicers. Borrowers who can pay their mortgage should, because missed payments remain the obligation that will ultimately have to be repaid. Lenders will begin offering the payment deferral repayment option starting July 1st, 2020. Next slide, please. So homeowners can apply for forbearance on their home. So homeowners should contact their lenders or servicer to see if their mortgage is backed by the government and check to see if their forbearance or payment option will be, what their payment options will be. This will be a state by state and lender by lender. Understanding your payment option is of great importance. There are some options where homeowners can pay a portion of their mortgage and roll the balance of the payment to the end of the agreed term. Also, there are some lenders that are allowing homeowners payment plans. Some lenders will give you the option up to 6 months, and at that time you can assess your financial situation, and if you need to extend it, you can. Homeowners need to keep in mind that these payments still include interest, and some lenders may require you to make up a lump sum payment at the end of the agreed forbearance term. You must be clear on the terms. And it's also really important, just like we heard testimony from the Landlord Association, there are many times that these people do not have the options that we're talking about because they are not COVID related. They were in trouble long before COVID came along because they were not being responsible. We should not be turning around, and we should not be sitting there and having these situations where we're bailing out people who were not responsible. We should be helping people who were being responsible, but we should not be helping people who are jumping on the backs in the bandwagon of these that were taking advantage of this situation. Next slide, please. So these charts reflect the change in the forbearance loans and the impact that COVID-19 virus has had on the mortgage sector. The data is from the Mortgage Bankers Association, and the data represents the share of the loans in forbearance. So we can see that in this chart that the total forbearance loans have spiked from 0.25 in March 2020 to 8.16 on May 10th, 2020. Next slide, please. So more than half of the home loans are backed by government agencies like Fannie Mae, Freddie Mac, and Ginnie Mac. Look at the government-backed portion of the mortgage market. We can see that Ginnie Mae experienced the largest growth in loans, and the biggest jump occurred the week of April 19th. The record filings for unemployment has led to nearly 7%, 3.5 million of all mortgage borrowers asking to be put in forbearance plans. Next slide, please. Another portion of the government-backed loans, Fannie Mae and Freddie Mac forbearance loans, have continued to increase from the 1.69 from March. I'm sorry, this was supposed to be, the Freddie and Fannie, sorry. For 1.69 to 6.25 from March 30th, 2020 to May 10th, and these levels are gradually slowing down. Next slide. And then the independent mortgage bank loans are a very important piece of the picture. This is the one that I talked about in my amendment. So the piece of this picture is because this represents the loans that are not backed by the government. These are independent mortgage banks loans grew from 3.45 to 7.85 from March 2nd to May 10th. Support for this portion of the economy will be important, especially when the moratorium is lifted on the evictions and the foreclosures. We still haven't addressed the issue of the impacted commercial landlords on our main streets. And these are the landlords that have been heavily impacted by the health orders and the shutdowns. The economic impact has drastically affected the commercial real estate industry. However, we're not addressing this in this bill, nor having that conversation yet. They are the ones taking the brunt of this by not receiving rent payments when our businesses can't make their payments, or when the businesses can't reopen because it's economically not viable. These are the type of mortgages I was trying to address by my amendment during our special session, as they're not federally backed mortgages and are not protected. I respectfully ask the committee to consider the commercial owners when you debate this issue. Please reconsider my original amendment from our special session that removes all the mortgages and only protects those that are contract for deeds and in-house mortgages. And it is my professional experience that homeowners are more sophisticated than renters and will seek out the help in protecting themselves and protecting their investment. Next slide. The next slide. So the remainder of these slides are basically the highlights of a letter to Congress from the National Association of Realtors addressing the concerns about renters and housing stability. I've posted the link to the letter and wanted you to be aware of our concerns as realtors as we examine our own law and moving forward. The housing is stability in our economy and the mainstay across all industries. If our people don't have a roof over their heads and have a bed to sleep in at night, nothing else matters. Because without an address, we don't have access to benefits. We can't contribute to communities where the likelihood of crime and incarceration increases, and the likelihood of our youth dropouts increase. Statistically, our communities do not thrive, but they rather dry up and fold. Healthy communities are the communities that are made up of stability, stable communities. And that's the bulk of my testimony. You can slowly go through the next few slides. And it basically addresses that the Household Plus survey showed that nearly 50% of respondents reported that another adult in their household had lost employment since March 13th. And it just goes on, and you can go to the next slide. It's pretty drastic. And some of the big important parts in the letter talks about the vague language about the evictions, and so there's some real concerns about from Congress, from the realtors, about the congressional language in the moratorium. So it's pretty important for us to be aware of what the realtors have to say about the congressional language and moratorium. So it's important for us to be aware of that. And in closing, I want to really point out my concerns personally from the testimony of the landlords is, and you can close out the slide. One of the most concerning things for me too is about the testimony from the landlords is that, we passed a Fair Housing Act several years ago. And it's still sitting out there. It hasn't been put into place. And what has been brought to light by the landlord testimony and is really concerning about the COVID-19 situation is there's a lot of fair housing violations probably out there right now. And as she's testified, there's a lot going on. And so the fact that we still have a bill that we have passed into law, but it's not implemented and it has nowhere it's been, that should be concerning to us. So, so that's basically where I'm at. So again, I think this is a great step. It's a great bill. I still agree with the renters part, and I still think it's important that the renters apply and it goes to the landlord, because if a renter gets the money, there's no guarantee that the landlord is going to get paid. So that's important. But as far as the mortgages, again, I'm adamant. The mortgager, the homeowner is protected. If they have a federally backed loan, they're protected. But we need to protect, again, like I said, we need to protect those that aren't protected. And that's the contract for deed, which are the local banks, the local people who are you and me, who've done a contract for deed. That's seller and buyer who don't have a lender in the middle. And then we need the in-house loan. So it's the local, it's going to be your local banks. It's not going to be your federally backed or your secondary market. It's going to be that the in-house local bank. And that's what that's going to be. And so that's what you need to do, is protect those two types of mortgages. So that's what the gist of what my amendment was that didn't get carried over from the session. So I stand for questions. I'm sorry I took so much time.
No, thank you, Representative Duncan. That was a good, clear presentation. I see that Mr. Oversland has a question or a comment.
And yes, thank you, Chair. I just want to thank Representative Duncan for her discussion and let her know that when we did our emergency rules, I took the 36 hours of special session and I watched most every minute of it and took those comments, her comments on that and amendment into consideration when WCDA did the rules. And on the mortgage side, under section 5A of the rules, we say to bring mortgage loans current for homeowners that without federally or privately insured mortgages who are not eligible for a forbearance program. So that's what we're trying to take into considerations, are those bank loans and those contract for deed types of things that people can apply for. And if a borrower has a forbearance program, that will take care of them. And we do not need to use this 15 million that was appropriated to us for those items. So thank you.
Representative Stith.
Mr. Chairman, thank you. Representative Duncan, thanks for the presentation. On contracts for deed between private parties, is there any concern about whether the state has the power to, alter their contract?
Representative.
Thank you, Mr. Chairman. I would suggest, well, this is where I'm at. A contract for deed in my realm, and I know you've done some real estate transactions and contracts. I don't find them to be necessarily valid in my world unless they have been filed, for one, and unless they have an escrow agent. I refuse to do any unless they involve an escrow agent, and such, and if they've been filed. So I guess you would have to, I don't know. I guess it would be one of those, you'd have to apply and you would have to show that they would be late. And so you would have to file, because in order to file bankruptcy and in order for them to be valid, they would have had to been filed with the courthouse. Because I've had some that were, they've gone, the owner who has the original mortgage has gone bankrupt and they've done a contract for deed, but it never was filed. So the person who was doing the contract for deed had no say so. So they really didn't have a valid contract. So that wouldn't be valid. So I guess I would say that the only way that it would be valid is if it was originally filed, correct?
Mr. Chairman.
Representative Stitt.
And so from a point of view of what the legislature can do, Representative Duncan, just so I understand, I think the gist of your third amendment there to House Bill 1002 was to allow some of the CARES Act money to be used to supplement the payments that otherwise would be made, or am I misunderstanding the purpose of what you want to see done?
Mr. Chairman.
Representative Duncan.
So, thank you, Mr. Chairman. So I would see that the contract for deed, if you were going to use it in the CARES Act, you would use it the same way as if you had a traditional mortgage. So it would be that they would have to have filed like a traditional mortgage. So if you were a contract for deed, you would have gone through an escrow agent and you would have filed it with the courthouse, like a traditional mortgage. The difference is you were going through, like I was buying a house from you, contract for deed. And the way I would do it is I have a promissory note and I would have had it filed at the courthouse as a promissory note, contract for deed, except you're the one who's carrying the mortgage, not a lender. And I'm making payments through an escrow agent. That's how I understand how we do it in my industry.
Senator Von Flatern.
Thank you. Representative Duncan, did WCDA do basically what your amendment would have done?
Representative Duncan.
Thank you, Mr. Chairman. I'm learning it for the first time now. Yes.
Mhm.
And Mr. Chairman, follow up.
Yes.
Thank you. My objection to what had happened was that we opened it up to all mortgages that were federally backed. There's no reason to use CARES Act funds for federally backed mortgages, because my argument is that homeowners are more sophisticated than renters, and that's a small amount of money in the big picture that is not going to go to renters that are the ones that are truly needing it, and those landlords. And truly, our commercial landlords are in dire need right now, because if you look at Main Street and our commercial buildings and businesses across the state, majority of our commercial businesses and things, those are renters. A lot of our businesses are renters, not owners. And because I could point downtown and around, the majority of those are renters, not owners. And I can tell you a lot of them weren't paid. And we haven't addressed that.
Any further questions? I have a question for whosoever. Did our bill in any way tie the hands of landlords? Ms. Gleam mentioned the idea that there are certain evictions that aren't based on a failure to pay, that they ought to be able to evict them if they're kicking a hole in the wall or whatever. Did we tie landlords' hands with our legislation that we passed in any way from taking care of their property in ways like that? Representative Duncan.
Thank you, Mr. Chairman. I didn't see that our bill had anything to do with, if you are and it depends on your lease, individual leases. And in my experience, if you've got a negligent tenant, you have, it all ties back to your lease. And if you've got a negligent tenant, you have ways to kick them out. But our problem is that we don't have any landlord tenant laws on the books, period. And so we don't have any rules and laws as far as statute for landlord tenants, period. And so that's the bigger problem. But I don't think our bill addresses anything having to do, it has to do with, you can't kick them out because they haven't paid because of COVID. But if they were not paying before COVID, you could still kick them out. It had nothing to do with, because you could prove, because I could prove that I had tenants that weren't paying before that. I could prove that. And I could have evicted them because of that. But I didn't see anything that prevented me for that. But we have a bigger problem with landlords and tenants that has been existing for quite a while, that our statutes don't address.
Okay. Anyone else? Ms. Glean?
Mr. Chairman, no, the financial bills that you passed didn't really affect the landlords. The landlords had their hands tied by the actions of the courts not taking hearings and stuff, but not by the financial stuff that you passed recently, that didn't really come into play. And so I would agree with Ms. Duncan. As far as what I disagree is, the courts weren't allowing us, even if a tenant was $6,000 or $7,000 behind before COVID hit, because it was a financial matter during COVID, they wouldn't allow us to do that eviction initially. The courts are now allowing some of those to go through, but up until literally this week, getting those high dollar unpaid evictions, we couldn't do during COVID.
Thank you. Representative Salazar?
Thank you, Mr. Chairman. So I guess I just want to get clear in my own mind, because I have had a number of constituent calls on this issue, and maybe Representative Duncan can square me away. For those renters who have been affected by COVID, who cannot pay their rent, are they currently protected? Can they be evicted for non-payment if they can prove they lost their job because of COVID and now they cannot pay their rent? What is the status in the state under that scenario? Thanks.
Ms. Gleam?
Under the that comes back to what Representative Duncan said about how is the mortgage and what type of rental are they in. If they are in a tax credit property, if they're on a voucher, if they're lower income, so they're on, or the landlord has an FHA-backed mortgage, one of those, no, nothing can be done to them at all currently until July 25th. Although that doesn't mean that they're not going to lose their utilities come any day now. If they're in a private mortgage, yes, they could be evicted today.
Anything else, Representative Salazar?
Yes, thank you, Mr. Chairman. So then let me ask you, what happens after July 20th? What happens after the July date?
Ms. Gleam?
So on July 25th, the first step would happen was they would probably get a 30-day notice to quit. That gives them essentially 30 days to either work it out with the landlord or come current on rent. At that point, if they don't do anything, approximately August 25th, forcible entry and detainer will be filed by the court. According to state statute, that must go to hearing within 10 days. Most courts, the court's going to have a little bit of a backlog, and we have Labor Day sitting there. But sometime around September 10th, they will have a hearing in court. They'll go into court, and it'll be up to a judge as to what to do. Typically in Laramie County, the judges will listen to the case. Most people get about an additional 3 days, and then they have to be out. And I will tell you, on these FED hearings, we have about 95% of the tenants not show up to the hearing.
Senator Cost? Senator Cost, did you have a question?
Thank you, Mr. Chairman. I'm not sure whether this. Are you hearing me? Can you hear me?
It's modeled, but I think we can hear you.
Yeah. Internet is unstable all of a sudden. If you can ask the question in a little bit.
Okay, fine. Are there any other questions?
I do.
Madam Co-Chairman?
Thank you, Mr. Chairman. I have not found my hand raise button quite yet because I haven't needed it so far today. A question for Ms. Gleam, which is based on Representative Salazar's question and concern. do you have any solutions or thoughts for how we can maybe guide the courts or guide landlords and provide some a process or some assurance for landlords, tenants, and the courts for what they do after July 25th? And further direction, I think, for the committee, Representative Salazar, that July 25th date's based on the federal legislation that was passed and applies to everyone based on those federally backed loans. That's the nexus there that makes it apply. But we are kind of in this point of struggle. I mean, the courts don't want to be in a situation of forcing people out in 3 days as what they typically do for a failure to pay. You know, just knowing that they're not as heartless as people think. Those lawyers, they were children of people once too. You know, that what solutions or compromises or middle ground do you think can be made to protect all the parties? Any thoughts there?
Ms. Green?
I would love to go back to our original addendum that we came out with in March that negotiates that unpaid rent so that the tenants could pay a portion of the unpaid rent, but it must be paid in full by the end of next February, because that's when they're most likely, a lot of these tenants will see larger than usual income tax refunds. But get them to pay normal rent plus a portion of the judgment. Maybe we stick it in something where we'll go ahead and take payments, but if you miss a payment, then the eviction is going to hit, and get them onto normal payments. We run the true tenant that is struggling versus the tenant that's going to abuse and take advantage of the situation all the way through. And to be very honest, if a tenant is $6,000 or $7,000 behind in rent, and we have tenants that far behind, there's no catch up. That particular tenant, if they owe that much, you know, you're acting like a catch up payment would be $1,000. Plus their regular rent, you're looking at $2,000. There's no way they're going to have that type of money to catch up. That's not a reality. And the problem is we frequently will send tenants to places like Community Action in the churches and 211 and stuff to get a rental assistance. Many of those agencies don't help if the tenant owes more than $1,000. And I don't know if there's a workaround with WCDA that we could do this. But, you know, a little bit has to be left to the judges. Some of these tenants, they're frequent flyers in the courthouse. You know, we have to distinguish between our frequent flyers and our people that have really never seen an eviction, always been current on the bills until COVID hit on March 15th. And one other consideration that we can't totally ignore, what about round 2 of COVID? What do we do then?
Madam Co-Chairman, you're good? Senator Cost, do you want to give it a try?
We'll give this a try again. I'm on my hotspot now, so maybe it'll hold steady. I think this is either for Representative Duncan or for possibly Mr. Hoversland, but what would we need to do, or should we consider doing to help the commercial renters and that aspect of this, or is it covered in the bill that's suggested by Mr. Hoversland?
Would either of you, Representative Duncan?
Thank you, Mr. Chairman. The way I understand the original bill was written, it was written for residential. So, and WCDA, from what I understand, they take care of residential. So it would require some changes.
Sorry.
So it would definitely require some verbiage changes. But yeah, it's a serious problem that we have, because if you look at what we're trying to help and address in our 1004, we're trying to address our businesses, but our businesses, that's just helping stop some of the bleeding. But if you want to really make a difference, we need to get to the head of the problem. And, you know, that would be the actual business owner on Main Street.
Mr. Hoversland?
Yes, and I think that is, I agree with Representative Duncan that the way the initial bill was, it was for residential rent. So that is not covered. And I think that would be something that hopefully, the Business Council could cover or would be looked at in later legislation.
Okay. Let's go to Representative Stiff.
Mr. Chairman, thank you. For Mr. Hoversland, is it fair to say that right now, under the program that you just opened up this morning, that landlords can apply and tenants can apply too, and if they otherwise meet the criteria, they get rental assistance and even mortgage assistance right now, right?
Mr. Hoversland.
Mr. Chair, Representative, yeah, landlords, it's the renter that needs to apply. Landlords should talk to their renters and note that the program's out there. It's relatively a short form. That a lot of our time was spent on making sure that we had a form that was online. We can also mail out packets, but we wanted to make sure that availability was there so it can get done. I think our first one completed package came within 2 hours of putting it up there, and you have to have your lease agreement and some current pay stubs and that type of information. So we hope to get first payments out within 7 to 10 days, and so that those can happen, and then they need to recertify for the upcoming months, if they're still eligible, after the 15th of the current month. So hopefully those can go out, and like I said, the program, if it's for rent, the payment goes directly to the landlord then, so they have that.
Representative Stiff.
Thank you, Mr. Chairman. Follow up for Mr. Hoversland. And just so I understand, if I'm a homeowner with a mortgage that's backed by Freddie Mac, for example, then I can also apply for mortgage assistance. But if I have a mortgage that's not backed by federal government, then I can't. Is that correct?
Mr. Director.
Mr. Chairman, Representative, no, if you have a mortgage that is backed by Freddie Mac, Fannie Mae, Ginnie Mae, those federal programs, then you're not eligible because you have the ability to request a forbearance and not make those payments now. So it is just those that are not covered by a federally insured or guaranteed mortgage that are covered under the program.
Let's go to Representative Washington.
Thank you, Mr. Chairman. For Mr. Hoversland, kind of bring this together for me. After hearing all that we've discussed today, are there statutory changes that you would recommend this committee bring forward?
Mr. Hoversland.
Mr. Chair, Representative Washington, I am not sure. I do not know, if there's any needed for, the program that we have underway. I think we need to watch and see how this affects, those payments. I think Ms. Gleam talked about the fact that, you're going to have some of those that don't apply for that. And that's the tough part. I think, we have to make sure that the landlords aren't negatively affected, and they could be, if they don't have federal mortgages, then on their rental places, they can evict. But of course, that's going to cost them too. But we can't make tenants pay rent and apply for the program that don't want to do anything. And that's the tough part, I think.
Representative Washington, you good?
We're good.
Representative Stiff.
Mr. Chairman, sorry, no comment. I just forgot to take my blue hand down.
Okay, very well. Representative Salazar. Yes, Representative Salazar.
Mr. Chairman, I guess after what I've heard, I'm wondering if there's any interest in the committee with regard to changing or adding commercial owners or landlords. I guess after after some of the testimony I heard, there might be an avenue to add some protections to those as well. But I just throw that out to see if the committee is interested in that at all. Thank you.
Okay, thank you, Representative. And we may get to that in a few minutes when we discuss any possible action. Is there anything else, committee, in terms of questions for our witnesses? Anything else? Because Representative Salazar, you're done, right? Your hand is up, but there we go. Okay. I don't see any more blue hands. So I would say, Ms. Gleam, Mr. Oversland, and Representative Duncan, thank you for good testimony and a lot of help you gave us understanding the topic in the last hour or so. So if you want to just remain in the waiting area while we process this a little, we'll see. Committee, is there any interest in any bill drafts coming out of our discussion today? Representative Washit?
Thank you, Mr. Chairman. I would move that we ask LSO to bring back that water bill. I think it was 2019 session, Representative Blackburn's bill on water utilities, and that we can consider that at our next meeting.
Is there a second? Moved by Washit, seconded by Pelkey. Any discussion on Representative Washit's proposal? Any discussion? Hearing none, we shall proceed to vote. All in favor of Representative Washit's proposal to resurrect the water bill, please put your hand up by your face. 1, 2, 3. I think I get at least 11, so that proposal passes. Are there any other?
All for the nays, Co-Chairman Kirkbride.
Anyone opposed? Please put your hand up. I see one. Okay, motion carries. Senator Cost?
I would move that we have LSO pull up some form of a bill to consider our commercial businesses with the understanding that if they have already received funding that was able to cover their rent, they can't get double. But if this would assist them, I think we need to consider it. And so I would ask that they put together some kind of a bill towards the rent for commercial businesses.
Okay, is there a second?
Second.
Representative Salazar with the second. Any discussion on Senator Cost's motion? Representative Pennell?
Thank you, Mr. Chairman, but I was planning on another motion and it doesn't, it's different than this. Thank you.
Okay, very well. We'll get to you in a few moments. Representative Stiff?
Mr. Chairman, I wonder if we need to look out for commercial tenants just because, we've got the Bill 1004 that has $325 million in it for small businesses. And Walmart, for example, is a tenant here in Rock Springs of a facility. And so I just don't know that we need to spend public money to help Walmart pay its rent.
Let's go to Mr. Fuller for a moment.
Yes, Mr. Chairman, just along those lines, I was going to note that House Bill 1004, the program, I guess I'll just characterize as the Section 3 program. So the largest program in that explicitly notes that funds received can be used by a business to pay rent or mortgage payments.
Okay. Senator Von Flatern?
I was just wondering if that excluded the businesses from applying for rent assistance. So I didn't know that. The bill did.
Okay, Senator Cost?
Yes, and if that's the case, which obviously I totally trust Brian, so I have no question on that, I would withdraw my motion.
Okay, motion is withdrawn. I see a couple blue hands. Are those legitimate blue hands or holdover blue hands? Representative Pennell.
Thank you, Mr. Chairman. I was thinking about, or well, I would make a motion that possibly that would deal with the landlords that where the tenants are not applying through WCD to get a loan for those direct payments to the landlord. So I would like to see some type of an amendment to the bill that we did draft that would cover that, would allow the landlords to file if the tenants, haven't done so. And I don't know how to word it, but I would like to make that into a motion that LSO bring that up in our next meeting.
Senator Von Flater?
So well, we need a second on this.
Second from Pelkey.
Okay,
Senator Von
so,
Flater?
yeah, so the discussion, Mr. Chairman, would be whether or not the landlord could apply. If the landlord can apply, why would you worry about the renter applying himself?
Representative Pennell?
Thank you, Mr. Chairman. The reason I'm saying that is that, as we've heard, there are some cases where this would only be if the tenant didn't apply. If, in those cases where the landlord was basically left holding the bag and was not receiving any income, couldn't follow through on evictions, or could, I guess, is the way I understood it, but that was still going to cost them money. So this is just a kind of a gap or to fill the gap so that they did get their funds.
Senator
I hope
Von,
that answered your question.
Senator Von Flater?
Once again, if it's under 25%, I can see where Representative Parnell's thoughts are correct. But if it's 25% or more, which would be a quarter of all your renters are not applying, then you could apply yourself. And so I don't see why we need a bill for the landlord applying, or amendment to the bill for the landlord applying for what should be his right to apply anyway.
Right. Representative Jennings?
Yeah, thank you, Mr. Chairman. Just a question for the bringer of the motion. So I guess my question would be, how would you keep both of them from applying? How would the landlord know that the renter had not already applied? I mean, it looks like there could be some problems there with tracking. How would you keep that type of thing from happening?
Representative Pennell?
Thank you, Mr. Chairman. Representative Jennings, I would think through the process where they're going to the one through WCDA to make that application, they're going to know whether one or the other is applied. So they're only going to fund the one, I would assume. And that might have to be stipulated in the motion, but they're only going to one area to apply. They'll know if there's a duplication or a double, where they're getting double whammied.
Representative Stiff?
Oh, Mr. Chairman, sorry. I don't know if Mr. Hoversland is still available. I guess I'm just confused about the law we passed a couple weeks ago, what it does. Are there any circumstances under which a landlord can apply? Or is it just tenants? I thought Mr. Hoversland said it's just tenants who get to apply. I may have misunderstood that.
Mr. Hoversland? You're muted.
Oh, Mr. Chairman.
Okay, we have Mr. Hoversland first.
Yes, I was in the waiting room, so I didn't quite hear what the question was.
Okay, Representative Stith, would you like to repeat your question?
Yeah, Mr. Chairman, Mr. Hoversland, I was just clarifying. I thought you had said that under your program, it's only the tenants who can.
Yes, and under the, oh, hold on one second. Under the current program that we released today, the Wyoming Housing or Emergency Housing Assistance Program, and the emergency rules that we set up, it is just directed to the tenant. The way the Senate File 102 has, the first part of that is to the landlord, but the rules didn't stipulate anything about the landlord payments.
Okay, thank you. Anything else? We have Representative's motion is on the table. Any further discussion? Representative Pennell?
Thank you. I did have a question for Mr. Oversland in regards to that question that I had, that if we were to make an amendment, if we were to pass this amendment that would basically allow landlords to file in the instance where the tenant wouldn't, they would have the knowledge to know that only one party would be applying if the, because the question was whether the if the tenant applied and then the landlord applied. So it would all come through their area, and so you would know if it was duplicated, correct?
Mr. Oversland?
Mr. Chair, Representative Pennell. Yes, right now, when the tenant applies, there's a verification form that the landlord has to fill out of that is a renter, and the amount of rent that is due on the property. So we know from that who the landlord is. So if a payment was made on behalf of a renter, we know we're paying that already. And then that would be something that the landlord wouldn't be able to receive twice.
Thank you. Anything else? Any further discussion on Representative Pennell's motion? Hearing none, we shall proceed to vote. All in favor of Representative's motion to allow landlords to apply in the case when renters are not applying. All in favor, please raise your hand up by your face. 1, 2, 3, 4, 5. I'm up to 7. So 7 in favor, all opposed, please raise your hand. 1, 2, 3, 4, 5. Representative Pelkey, I may have missed you. Did you vote for? Okay, you did. So I think I might have missed one. Can we do the 4s again? All in favor, please say aye. 1, 2, 3, 4, 5, 6. Now I'm down to okay, 7. Now 8. All right. 8, 4, all opposed, please raise your hand. 1, 2, 3. I think it's 8 to 5, the motion passes. Committee, is there any other ideas for action stemming from our discussion this afternoon on landlords and tenants? Any further discussion? Okay, then I think we can close that session. Again, thank our 3 witnesses that came and helped us out. Committee, why don't we take about a 5-minute break, and then we'll come back at 3:15 and finish up our work. Committee, looks like we're ready to go again with the quorum. So let's move to our fourth topic of the day, review of criminal justice system operations. And Mary Beth, if you could admit the witnesses into the room. And we'll see Director Lampert and Mr. Odekoven. We have actually, I think, as many as 8 witnesses. Well, why don't we start with you, Director Lampert, if you'd like to beam up. And we're interested to hear how it's gone in your world during the virus. We've read some about that.
Can you hear me, Mr. Chairman? I don't see my video, but.
I can hear you and I don't see your video.
Okay, how about now?
There we go. Director Lampert, please proceed when you're ready.
All right, Mr. Chairman. I'm Bob Lampert, Director of the Department of Corrections. We may have a few DOC employees joining in. I think Deputy Director Shannon and maybe Paul Martin. Anyway, I'll present the bulk of the testimony and defer to them if I need to. Mr. Chairman, you asked for a summary of our operations since the onset of COVID-19. And so I'll talk about that, the things we've done. But let me start with the great news first. We do not have any confirmed cases of COVID-19 inside any of our 5 prisons. While there's always the possibility of the infection coming into our facilities, we're also prepared to address the incident and minimize additional spread should it happen. But our best defense is prevention. We've had 1 staff member confirmed for COVID-19 since the outbreak occurred, but that person did not expose any other people, has fully recovered and is back at work. We've had some other staff show symptoms and self-quarantine, but none of them subsequently tested positive for the virus either. We have had and do have a few staff out on COVID-related leave, but most of those are related to child daycare issues or because of a potential direct contact with somebody who's tested positive. But again, thankfully, we've only had 1 staff that ever tested positive. We do have some testing capacity for inmates. We've tested 32 inmates to date because they've exhibited flu-like symptoms, but none of them have tested positive for COVID. As we are only one of 3 states with no COVID-19 cases inside our prisons, people are probably wondering how we've done that. And I think Warden Pacheco from WSP in a recent newspaper article summed it up probably better than anybody when he said by hard work. We took fairly aggressive action early on system-wide. We enacted certain restrictions and prevention protocols, and we did that as soon as the governor declared a state of emergency and public health emergency. We already had in place a pandemic influenza response plan. So we immediately began amending it to match recommendations that were coming out from the CDC, World Health Organization, and the Wyoming Department of Health regarding COVID-19. Deputy Director Shannon, Prison Division Deputy Administrators, Julie Lieutenant Kane and Scott Abbott, the wardens, and then work groups from each prison, including our emergency coordinators and contract medical staff, worked hours on end, racking up several hundred hours in COVID-related time, finalizing our detailed response plans. But I think their work has paid off. Even while our response plan was still in development, we immediately curtailed staff travel, limited inmate transports to essential transports only. We also initiated enhanced cleaning and sanitation regimens at all of our locations. We started to educate staff and inmates about the virus, the risks that presented in high-risk categories, and how best to prevent it and slow its spread. We obtained and gave inmates additional hand soap, cleaning supplies, hand sanitizer, and we trained them on how to use it. We also implemented social distancing to the extent it was possible and limited group sizes to 10. Some of our other additional first steps were to stop inmate visitation and volunteer programs. And we did that in order to limit potential exposure. To offset to some degree the lack of visitation, we implemented 2 free phone calls per inmate per week. We did that by working with our inmate phone provider to make that happen at no cost to the inmates, their families, or to the state. Most recently, thanks to the efforts of the 5 wardens, we also initiated limited access to televideo visitation, which the inmates and families have really appreciated. Early on and ever since, we've reminded staff not to come to work if they are sick, told staff who are at work to go home if they became sick while at work. We started doing medical screenings and temperature checks on everyone coming into our institutions and offices, whether they be staff or incoming inmates or visitors or contractors. We restricted the size of programming education groups, reducing the number of inmates allowed to congregate in the same location at the same time, including in the dining room and gymnasium, for example. And we encouraged inmates to socially distance to the greatest extent possible. Then, as revised telework guidelines came out from the governor's office and ANI HRD, we encouraged telework of staff to the degree possible, considering we're a 24/7 operation, particularly in our field services offices. As a result, we currently have about 22% of our workforce on full or part-time telework. We reduced our face-to-face contact with probationers and parolees by modifying operations. We're still providing supervision, but we're relying more heavily on technology to keep us in contact with the offenders. Interestingly, one of the results has been fewer returns to prison for technical violations, although we have continued to use sanctions just as robustly as we did previously. Another reason is likely a decreased use in random drug tests, as we've changed to for-cause testing only in order to reduce the potential for staff exposure under COVID-19. We started to get some requests from prosecutors and communities to begin to ramp up that testing again. And that'll be part of our ramp up process once we get to that level. Inmates in our prison industries program came up with a prototype for cloth sneeze guards, as well as face shields and water resistant gowns. We've produced thousands of sneeze guards, so every inmate and staff member has been issued 3 cloth face coverings. Once we got everybody a sneeze guard, wearing a face coverings became mandatory for all staff and inmates. We did that just a few days after the CDC updated their recommendations regarding the wearing of face masks. While we reduced the number of inmate transports, we did not eliminate them. We still transfer inmates from facility to facility to manage bed space, and we still take in inmates from county jails, but we bring in new inmates in groups instead of singly. Before we pick them up from county jail, we're in contact with county jail's medical authorities to verify that they've not had any symptoms. Then before they're allowed on the transport vehicle, they're screened and their temperatures are taken. The inmates are required to mask up, and the staff are also required to wear PPE during the transport. Once they arrive at our institution, the inmates are screened again, their temperatures taken again. Then they go into medical quarantine as a group for 14 days before they're permitted to interact with the rest of the population. As we begin to return inmates from out of state rental beds to reduce costs, we'll use those same protocols to protect our on-hand population from incoming groups. We take a similar approach to medical separation for any inmate in our existing population who begins to develop a cough, fever, or any other symptoms, or has been in direct contact with somebody exhibiting those symptoms. We place those individuals into quarantine for 14 days along with their cellmate in separate cells, but in the same area as their cellmate. At the end of the quarantine period, if they've not developed any symptoms, they're returned to general population. Once they're tested and show negative, however, they're still not immediately returned to population if their symptoms have persisted or are worse than when we quarantined them. So they would remain in quarantine and then be tested again. We follow CDC guidelines for the release from quarantine or from medical isolation. And those, as I recall, are about 7 days symptom-free with no fever. Medical quarantine and medical isolation are not like restricted housing. So we've educated our inmates on that in order to keep the inmates from not reporting if they're sick, or from having other inmates report if they notice somebody who's seeming sick. We've made sure that the quarantine allows for as close to normal privileges as general population does. The inmates in quarantine are allowed to keep their property, and they can still interact with others who are also on quarantine. So they're still permitted outside their individual cells, but they're quarantined in a separate area. So they can't interact with others who are not on quarantine. Each of our institutions has an area or areas designated and reserved for inmates on quarantine, and a separate area for medical isolation. If somebody is placed on medical isolation because they're symptomatic and we're awaiting test results, then the inmates are restricted to their individual cell, and they're kept in a single cell with at least 1 cell separation from anybody else who's also on isolation. They're required to wear a mask anytime anyone enters their cell. Their cell is thoroughly cleaned and disinfected at least daily, and anyone entering the cell is required to don PPE prior to entering. So there are additional safety protocols in place around isolation as well. We had 14 or 15 of our staff and treatment providers trained by the Wyoming Department of Health to be contact tracers. If we do end up with a positive inmate, they'll immediately begin contact tracing of that individual inside the institution. Anyone from outside the institution who also had direct contact with the positive inmate would be contacted by Department of Health, who would complete the contact tracing outside the facility. Because our staff are more familiar with the institutions, the physical layout, as well as the inmates and their daily routines and who they hang out with, it made more sense to us and to the Department of Health for our staff to do the contact tracing for anybody inside showing a positive result. It also allows for a more immediate response to any potential exposures, which would then allow us to more immediately quarantine, isolate, and limit any spread. Although some states have mass tested their inmate population to determine the degree of spread and to identify non-symptomatic carriers, neither I nor the Department of Health believes that would be necessary at this time, and might use some limited number of available tests. If we do end up with positive case and contact tracing indicates more than a minimal direct contact with others, or for some reason there's a delay in confirming it as a positive in order to avoid the super spreader kind of situation, we might then seek mass testing of the staff and inmates. But again, at this time, we don't think it's indicated to do universal testing. As for the mood of the institution, staff and inmates have been understanding. They're mostly appreciative of the efforts we've taken. They're starting to push back a little about wearing face coverings, but otherwise they've been pretty patient. We're developing plans for a phased step down, but have not initiated any reduction in precautions at this point. I'd prefer, and we'd prefer to see if there's any resurgence in cases within the community as restrictions are eased before we go ahead, or before we get ahead of ourselves, just because there's a few disgruntled people among our staff and inmates. With that said, our employees have really stepped up. Without them and their efforts, things would have been a whole lot different. They continued to come to work unless they've been sick and have taken on all tasks without hesitation, despite the unknowns. Mr. Chairman, before I talk about the costs of COVID-19 and some potential areas of spending or legislation,
Mr. Director, could I ask you to take a break for just a moment? Representative Pelkey's had his hand up for a while and has a question for you.
All right.
Thank you. Representative Pelkey.
Thank you, Director Lambert. Thank you, Mr. Chairman. I am impressed with the steps you've taken, but I'm a little taken aback by the relatively low amount of testing you've done. And I know that you don't necessarily personally feel that there's a necessity for that, but I get the impression you've only done 30, 40 tests in the entire system. How many inmates do you have?
Altogether,
Director?
including inmates, and Mr. Chairman, including inmates in rental spaces, there's about 2,000. We have about,
Follow-up?
Yes,
about
Representative,
1,500 in our facilities.
Representative Pelkey.
Thank you, thank you, Mr. Chairman, Director Lambert. And how many actual tests have you conducted?
We've conducted 32.
32 with that kind of prison population. I mean, I understand. Have you talked to healthcare professionals, those people who are familiar with epidemiology and the risks of the pandemic about what level of testing you should be conducting? And if so, what sort of response have you gotten?
Mr. Chairman, Representative Pelkey, we have, we're in regular contact with, with the Department of Health, and we're all in agreement that at this point, based on CDC recommendations, mass testing is not indicated. If CDC updates their protocols, then we may consider it. But given the fairly limited number of tests that are available in the state, and the fact that what we've seen from experiences from other systems that have engaged in universal testing or mass testing, including just at 1 o'clock this afternoon, I was involved in a webinar with those individuals for over an hour. And based on their individual results, at this time, it's just not indicated.
One more, Representative Pelkey.
Thank you, Mr. Chairman. Director Lambert, obvious follow-up question is, do you have any difficulty obtaining testing equipment should you desire to expand the number of tests that you currently conduct?
Director Lambert.
Mr. Chairman, Representative Pelkey, we would coordinate with Dr. Harris to provide an widespread testing should that be indicated. We have ability to test what we, if a contact tracing indicates any, if we have a positive test, or if contact tracing indicates a need to test further, we have on-hand supplies of tests to handle a limited number. But should it be, a full institution, 500 people or 300 people, then we would coordinate that with the Department of Health.
Representative Washington.
Thank you, Mr. Chairman. Director Lambert, I want to commend you and your staff for all the hard work and hours of putting this plan together, and the success is nice to hear about. My question is, have you learned anything through this process that might have started you thinking about keeping some of these processes in place long-term, such as only doing group transports instead of individual transports from county jails and so forth? Might that be something you want to do even after COVID? Have there been any other lessons like that?
Mr. Chairman, Representative Washut, again, I'm in regular communication with all the directors across the nation through the Correctional Leaders Association. We have a Western Regional weekly meeting, televideo meeting with the directors from the Western region. Some of those have had, well, again, we're only one of 3 states all in the Western region. That's us, Idaho, and Hawaii, who have not had any cases. So we're able to learn lessons from all those others, including Ohio, who was on the call earlier today, Michigan, who's another active, I guess, COVID state. Let's see, New Jersey was another one, and Colorado. All those states have had fairly widespread outbreaks. Most of them have engaged in some universal or mass testing. And so we're learning lessons from all of those and what they failed to do early on. So those lessons we carried forward. Now, as those agencies are more advanced in the process than we are, because they've been engaging with it and developing protocols to deal with the actual pandemic inside, and then step down from that. We will be learning lessons from them as well as our own lessons. So to answer your question, some of the precautions that we have in place will be long-term. we will probably not phase down as quickly as communities do, simply because we don't have the ability to self-isolate and socially distance at 6 feet in every situation. So we may be slower to come off of the restrictions that we have in place. At the same time, we're going to adhere to the CDC and Department of Health recommendations around those matters. So we will probably do less one-on-one transports for intakes unless situations require otherwise. So I think we're in good shape to learn our lessons.
Representative Washington, anything else?
Yes, if I could, Mr. Chairman, one quick follow-up. Director, what's your capacity? If we were to have an outbreak and you're trying to quarantine a fair number of individuals in your prisons, what's the maximum capacity in a quarantined area that you could provide for?
Director?
Just a second. Mr. Shannon came and joined me in my office. You can't see him, but he's reminding me that we do it by pod or by unit. So basically it would be 40 or thereabouts that we would be able to quarantine at a time per unit in our larger units, because we single cell in those situations where we're quarantining. But if we had a widespread outbreak, we would just basically defend in place. That means that those who are potentially exposed, we would contact trace and maintain them on quarantine in their housing areas, rather than taking the risk that we missed somebody who was asymptomatic or simply hadn't tested positive yet, moving them to an area that wasn't in any way exposed at that point. So we have staged responses. Our best prevention is avoidance, and rapid response once we do have a positive case. But should we not be able to contain it to a single individual or a single group of individuals, then basically each unit, each housing unit, and each institution becomes a place to defend in place. And so that's how we would approach it.
Representative Washington.
Thank you very much. Nothing further.
Okay, Director Lampert, thanks for entertaining those questions, and please continue.
Mr. Chairman, in terms of the cost to the agency so far, I guess it kind of depends on how you want to define cost, but in my estimation, we're at about 2.9 million if you consider everything. Those costs have been accounted for, and an initial request for CARES funding was already forwarded through the budget office for consideration. Because that request is already in, I wasn't sure if you wanted to hear any detail about them or if you just prefer me to move on.
We're probably good for some detail.
All right, Mr. Chairman. In terms of direct costs, things that can be directly attributed to, I guess, a step up due to COVID-19, about $141,000 of our costs have been in those kind of costs. That's the things like additional personal protective equipment, additional cleaning supplies, those other expenditures that we would not have otherwise spent except for COVID-19. COVID-19 travel restrictions and precautions have delayed our ability to return inmates from out-of-state rental facilities. So that's kind of one of the more indirect costs. We had initially planned to begin bringing inmates back from Mississippi 107 days ago, but the pandemic interfered with our ability to transport inmates back safely. Private transport companies were not doing transports. States weren't allowing large groups of people to travel in a bus across their state lines, et cetera. So therefore, we've spent about $920,000 for out-of-state housing that we might have not spent except for COVID-19. We're presently finalizing our plans to expedite the return of those inmates. But there's an offset to that too, in order to make that happen, and it's a limited number of transports at a time. Our fallback was to pay the $95,000 necessary to bring them in a single plane, but that is off the table. So we're back to 20 at a time in buses. So there's going to be some additional time and expense to doing that. And again, as they come back, we would go through our regular protocols. Another example of the cost of travel restrictions that COVID cost us, we had an inmate in a medical facility to the state south of us. We were prepared to return that person, but the state had particular bans on release from that facility. So that cost us an additional $127,000. We had about $560,000 in additional overtime just to plan for and implement our response plan. We lost, this is small numbers, but lost about $5,250 in revenue through the industries program because we used to do hospital laundry at the Women's Center for the Lusk Hospital. We had to stop that because of the concern over the COVID virus. We invested about $11,000 in increased electronic monitoring for probationers and parolees, and we also had to enhance our assessment process to be HIPAA compliant and had to purchase that software. We also provided hazard pay for staff who were in direct contact with inmates, offenders, and the public for the months of March, April, and June. That additional add-on, I think, has had a role in a drop in attrition rates throughout the COVID-19 pandemic. We ended that on May 31st because we can no longer afford it. But we remain hopeful that that may be something that's reimbursed through COVID. So any reimbursement of the additional dollars that we spend as a result of COVID-19, of course, would allow for general fund money for either carryover or reversion. So that's kind of the cost that we've incurred. Is there any questions about those before I talk about potential legislation?
We have a question from Representative Pelkey.
Thanks. As an old journalist, I think you kind of buried the lead. I know that we're talking about COVID, but what is the reason you're able to, that you have the capacity to bring out-of-state Wyoming inmates back to Wyoming? Are we actually seeing a reduction in prison population here?
Mr. Chairman, Representative Pelkey, now what we've done is address the bulk of the issues at the state penitentiary, where we had to keep units vacant in order to move inmates, as we did corrective water mitigation and construction correction at that facility. So those beds are now available. We've also managed to, in large part because of pay raises that we were able to give through raising our entry level pay for staff. We've closed the gap in terms of the number of vacancies. So we have the staff necessary to staff those additional units as well. So in summary, we'll be bringing those individuals, or that number of individuals, back into the penitentiary, into vacant beds that have stood vacant longer than what we normally, or what we originally intended, simply because of the travel restrictions in place. In terms of the incoming population, Representative Pelkey, we're continuing to see the same trends as far as the number of inmates coming in. However, because we have had some impact on the level of revocations, we've gained bed space as a result of that. Not a large number, maybe about 40 beds.
Thank you, Mr. Chairman, and thank you, Director Lambert. Were we not to be facing this current COVID crisis, and you were able to transport prisoners back to Wyoming, at this point in time, how many out-of-state Wyoming inmates would you expect there to be?
Mr. Chairman, Representative Pelkey, if we brought people back into the state, given just the normal day-to-day need for flexibility to manage our population, we would probably have up to 40 inmates in county jails in Wyoming. And then we would bring those back as bed space allowed. But so we would eliminate all we would have already eliminated all out-of-state placements and reduced our number of in-state rental bed placements to about 40.
Okay, Director, you were about to talk about possible legislation.
Mr. Chairman, I guess potential legislation other than the possibility of looking at some possibly CARES money or whatever to reimburse some of those funds that have come out of our budget is more around the topic of early release, and it was my understanding that there was some interest in discussing that. So if there's no interest in discussing that, then that's pretty much the the bulk of the discussion around potential legislation.
No, I think there'd be interest. Why don't you tell us a little about that?
All right, Mr. Chairman. As several of the committee members can attest, there's been a call from community members and interest groups and others advocating for early release of inmates with an elevated risk of serious harm or death from COVID-19, primarily due to advanced age or pre-existing conditions like high blood pressure, COPD, and diabetes, etc. And some states have provided for emergency release process in statute in the event of a public health emergency. But Wyoming doesn't give the Department of Corrections that authority, and a parole board, for one, doesn't think the Department of Corrections should have that authority. So, but there are currently 5 mechanisms for early release. First of all is a court-ordered modification or reduction in sentence. The second is regular parole by the parole board. The third is medical parole, which widens the types of inmates that can be considered. And then there's the governor's commutation or authority under the Constitution. And finally is just completion of the sentence minus any good time earned. Whether there should be other means or whether any other existing mechanism should be expanded is something that is in the legislature's hand. But again, at the present time, the only authority the Department of Corrections has to affect sentence length is through the grant of good time. As you know, good time is authorized by statute and through the governor's good time of rules. Expansion of good time to include an ability to award additional good time in the event of a declared emergency was something that was discussed with the Board of Parole and the governor's office. It's not something that was adopted. There was also some question about would it make sense, or I think it was put, low-hanging fruit would be to change the effective date of the good time for jail time credit legislation that passed. Now we're into June and it becomes effective July 1. So frankly, I'm not sure that that juice would be worth the squeeze. If the legislature wanted to make a clear policy statement that releasing prison inmates in the event of a declared state of emergency early, particularly in the event of a state of public health emergency, it would be possible to add some language to the to Wyoming statute 1913-102C, and that's the governor's authority to declare a state of emergency. And I would simply add that the governor, in his sole discretion and pursuant to his constitutional authority, could consider commuting sentences of persons imprisoned in state penal institutions in the event of an emergency. That certainly wouldn't limit the governor's clemency power, and it would really not have much practical effect. It would just be clear articulation of public policy that the legislature was in support of the concept of early releases during a declared public emergency. So then perhaps a complementary approach would be to consider to amend the medical parole statute. That would just simply add a subsection authorizing consideration for medical parole in the event of a declared emergency. So it would serve as a catalyst for medical parole consideration in addition to the ones that are already out there. And I think I provided the chairs with some potential draft language on that issue. But I will say that I think the Board of Parole had some concerns about that draft language. An approach we suggested a few years back was the concept of home confinement as a step down mechanism for those inmates who aren't granted parole and are nearing completion of their sentence. Certainly that's something that could be considered by the legislature. And then a final approach would be the approach that some states have taken, which is to give the agency some discretionary statutory authority to release inmates, specific types of inmates, say with those within 6 months of expiration of sentence or those within a year of expiration of sentence in certain circumstances. So I think that there's some concern about separation of powers to that kind of approach, but it's worked in other states. So, Mr. Chairman, I think that's kind of an overview of the types of legislation that could be used in the area of early release if that was an area of concern for the legislature. It's not something that I'm necessarily asking for, but certainly there has been a widespread interest nationwide in that effort, and a number of states have incorporated some form of early release within their statutory authority. With that, Mr. Chairman, again, I would ask if there's any questions.
Any questions for Director Lampert on any of the material he's covered? I don't see any, Director. Thank you very much for your time and your explanations.
Thank you, Mr. Chairman. I would just like to ask Mr. Shannon if he has anything to add. He indicated no, and also Mr. Martin, Paul Martin, who's he's the Deputy Administrator for our Transparency Division.
Okay. Welcome, gentlemen. We do have Madam Co-Chairman with the hand up.
Thank you, Mr. Co-Chairman. I typically don't provide commentary because generally that's annoying, particularly in a long committee meeting, but I do just want to express, and I think the Joint Judiciary joins me in this, our profound pride and appreciation for all the hard work that the Wyoming Department of Corrections has done. It is pretty remarkable that we are only one of 3 states without an inmate with symptoms, and I don't think that's as a result of lack of testing. I think it is as a result of timely response, the professional leadership that we have, the ability to institute that change, and the continuation of implementing those protocols and in direct communication with all of the subject matter experts like Dr. Harris on the subject. So I just want to express to you just huge applause on that front. And it's hard to give that when we're not dealing with a crisis or trying to solve a problem, but you're just doing so remarkably well. I want you to know there's no pressure. Understand earning an A and keeping an A are 2 different things, and one is much harder, but we would be in such a different situation in this state in the event that you didn't respond so quickly and so timely and do such a remarkable thing. And I just want to make sure that gets communicated, just how lucky we feel and how grateful we are for you.
Thank you, Madam Co-Chair, and on behalf of all the employees of Wyoming who have really been the ones to do it, I join you in appreciation of them and their efforts.
Well said, Madam Co-Chairman, and that thanks extends right down to the people cleaning the cells, top to bottom. Well done. Representative Pelkey?
I just wanted to echo Chairman Nethercott's thoughts, despite my questions about the small number of tests that have been conducted in our system. I feel relatively comfortable with the work you've done, and I don't think that the absence of testing is necessarily hiding a bigger problem. And I appreciate everything you've done at the agency. So I just wanted to extend my thanks as well.
Thank you.
Thank you all. Okay, we'll move on to our next witness. We have Mr. Causey representing the Board of Parole. So Mr. Causey, if you would turn on your video and introduce yourself to the committee for the record, and we're interested to hear your take on things.
Certainly. Thank you very much for the opportunity. I am Mike Causey, the Executive Director of the Wyoming Board of Parole. Excuse my voice. I first and foremost thank all the members for the opportunity to appear by video. I think this is, indicative of the times we live in, and I know that it's not ideal for the committee members to certainly participate in a day-long video hearing, but it's what our board has also been doing. Since the start of this, even before the travel restrictions and what have you were in place, our board took steps to kind of mitigate any exposure that both the inmates would have, as well as the board members and our staff. And so what we have been doing is essentially conducting our hearings and other matters as much as possible by video or audio hearings. That hasn't really slowed us down. We have been doing it pretty effectively. We've had to reach out to the reentry staff in particular at each of the facilities. They've done a phenomenal job in trying to make sure that all their technology works. We've also had to make sure that our technology works on our end. There have been a few hiccups, but for the most part, it seems to work. We also, of course, conduct video hearings or audio hearings for victims and other folks who need to appear in front of the board. Staff has been working as much as possible from home because we have to have our office open, and because we get quite a few phone calls. We forwarded the messages to our individual phones, and we answer those. We have seen an uptick, if you will, in the amount of communications that we get from not only inmates, but parolees, as well as from our agents out in the field. We have quite a few of our agents who, as a result of COVID-related situations, don't quite know what to do. And so our staff has been very diligent in trying to work with them to come up with alternative means of dealing with these offenders rather than just simply trying to return them to facilities. With that said, I will say that there have been a few anecdotal cases that I can speak to in which our agents have told us that they have tried, for example, to have a person arrested and held because the person is absolutely failing on parole, multiple violations, not just technical ones. And as a result of the offender wearing a mask, local law enforcement refused to arrest. So those are the kinds of things that we have to deal with on a routine, regular basis, as well as trying to get our offenders back if need be for any kind of revocation or what have you. For the most part, though, I will say that the board does maintain its desire, its hope to resume normal operations. They have witnessed, I think the same as the legislature has, that there is something to be said for having these in person, giving the individual offender that opportunity to speak. That's one of the things that our state of Wyoming has been lauded on across this country, and certainly the board maintains that desire to have that happen again as soon as we possibly can. With regard to the possible legislation, I'll try to keep this short and to the point. Early release is something that the board doesn't necessarily oppose. However, it has some serious reservations about how it's done. Director Lampert had indicated that that the board was kind of opposed to this. Well, it was brought up during a meeting with executive branch officials. I think the general tenor of that meeting was there are a lot of issues that really need to be studied before we just jump on and adopt rules. This is certainly something that we don't want to take and make light of. We certainly want to get it right. And there are a multitude of factors that can affect this, not only questions like COVID and pandemics, but also the possibility of what if we have a natural emergency, a natural disaster. Those kinds of things could certainly be contemplated as part of any sort of legislation. One question, though, that does pop up is the facilities themselves have managed to maintain their COVID-free status, and yet we would be looking at releasing some of the most at-risk individuals back into the community. And I don't really know if that's a wise idea or not, but I think that's something that's definitely the legislature would have to look at, as well as the executive branch agencies that are responsible for doing this. We don't want to put a person at risk by ending their sentence early. By the same token, when we look at things like medical parole, one of the questions that we have to ask is whether the person being released is going to present some sort of a danger to the community. I don't know if we can certainly say with any sort of definitive answer that they don't. But those are the kinds of questions that I think we do need to study, we do need to contemplate. The other concern, of course, we have is that if you look at how the history of the Board of Parole exists, they are the parole release granting authority. They would like to maintain that. With regard to the question of should any one person have the authority to release folks, I think that one person happens to be the governor. And so there's a legitimate concern there as well that we don't step on the executive branch's authority, if you will, through that. But I think that there are certainly some possibilities for legislation. We would have to look at the individual specific language to actually make heads or tails of it. And I think with that, I'll just ask if there are any questions or concerns that perhaps I can address.
Any questions for Director Causey? Representative Pelkey?
Thank you, Mr. Chairman. Good to see you, Mr. Causey. You used the term at risk in terms of those individuals who may be released. What do you, what categories or what criteria are you using to define somebody at risk?
Mr. Chairman, Representative Pelkey, I think that's one of the questions that we have to answer. Who exactly is going to be eligible for this sort of special good time, if you will, to get them to discharge early? I believe that some of the language that I had seen from Director Lampert suggested that folks who perhaps could be at risk for contracting COVID or contracting some sort of a virus, it wasn't clear to the board or to me whether or not that limitation was going to be just the folks who, are you trying to thin out a population and not have folks who perhaps are a danger, if you will, if they happen to get it, they'll more easily spread it? Or are we looking at some sort of another answer to it? That I think is something we have to answer.
Again, Representative Pelkey?
Thank you, Mr. Chairman. I guess one of the criteria I'm curious about is a propensity for violence or a record of violence. I mean, it's certainly not, no matter what legislation we pass, I don't think it would ever be the legislature's intent to accelerate the release of potentially violent inmates or those inmates with a record, particularly of violent sexual offenses. Are those criteria being measured when you apply the term at risk rather than just the medical question?
Mr. Causey?
Mr. Chairman and Representative Pelkey, the language that I saw from Director Lampert, the answer is no. That there was not an inclusion of factors to be considered along those lines. That is something that is definitely worrisome to the board. Because, for example, we have folks now who are inside facilities who refuse to program. Some of the most violent sexual offenders or those sorts of folks refuse to program. There are some issues with how they get treated and whether or not they'll get write-ups as a result of their refusal to program. The board certainly takes that into consideration. They hear from victims all the time who say, please don't release this man or this woman because they're going to do it again. And that's something that the board definitely looks at because one of their primary functions is community protection.
Representative Pelkey.
Thank you, Mr. Chairman. This will be the last one. I'm just curious. So, Director Causey, would you be more comfortable if we, as a legislature, proposed legislation that advocated the accelerated release of inmates, but established some sort of criteria in terms of danger to the community? Because, I mean, fundamentally, that's one of the reasons they were sentenced in the first place. I mean, most judges use the criteria of a risk of recidivism and a danger to the community when imposing a sentence, which is why, the vast majority of well, in my case, the vast majority of my nonviolent offenders usually don't get jail time. Those who've inflicted violence or sexual assault on members of the community get fairly heavy sentences. And if we were to apply or at least put in legislation, the legislature's intent to make sure that it was those prisoners, the least risk to the community's safety, would you be more comfortable, and would the board be more comfortable with that kind of language?
I think that would certainly help, Mr. Chairman and Representative Pelkey. It would go a long way to addressing the community aspect of it, the community protection part of it. Certainly, we'd have to look at other conditions and make sure that it's kind of a well-rounded, well-reasoned approach, not just something that's put together at the last minute to try to get folks out of prison.
All the way up to Sheridan County to hear from Representative Jennings.
Thank you, Mr. Chairman. Mr. Causey, I guess I have this nagging question here that I, in light of the fact that we have no cases, can you explain to me, I mean, I realize that I could have asked this from Director Lampert, but from your perspective, do we have a problem with the way that we do this now? Is there something that we should be addressing? I just don't see the problem with the way we have this set up now.
Director Causey.
Mr. Chairman, thank you. Representative, I don't believe there is. And that's part of the issue that the board had with this approach. We certainly understand that there could be the possibility of needing to address this. We're not disputing that. However, looking at what has actually happened, the reality of it, I don't know that there's any indication that this has to be done right now, particularly not without any sort of a very clear path forward. And that's definitely one of the concerns that the board had and board expressed when we visited with both Director Lampert and Governor Gordon.
Committee, anything else for Executive Director Causey? Anything else? Right, thanks, sir. Thanks for sitting in with us today.
Thank you.
We have Mr. Riemann on tap here and the commissioners. Good afternoon, Mr. Riemann. If you'd like to introduce yourself, and be happy to hear from you.
Good afternoon, Mr. Chairman, members of the committee. My name is Jeremiah Riemann. I'm here on behalf of Wyoming's County Commissioners. I had planned to have two of my commissioners here today, but given the late hour, they were unable to join us. But I've gathered information from them and others that I'd like to share with you today. First off, we appreciate your taking up this particular issue. It is certainly something of importance to the counties. Throughout this COVID experience, counties and their personnel have been on the front lines working to address not only public health emergency, but also maintaining the peace and safety within their communities. Commissioners had the difficult task of considering whether to limit or in some cases close their county courthouses, which was not something that they might have preferred to do. That particular action, of course, came with close coordination with a lot of different entities, but most importantly, our court system and the Supreme Court to determine how we could ensure the proper coordination of the criminal justice system throughout this process. We've also had to work very closely with our counterparts in the county sheriff's offices to ensure that our jail population and the staff that work there on a daily basis had not only the equipment that they needed for that activity to carry it out safely, but that we did not have any sort of outbreaks in that community. I will share, and I think you've heard, efforts in other states have not been as successful as they have been in Wyoming. We have seen incredible outbreaks, both in the state and the county, as well as the federal systems of our jails. And some of those are the most pressing outbreaks in their communities. On the topic of the criminal justice system, when I surveyed my members, a couple of things came up in that conversation. And I know we've talked a little bit today about states releasing inmates early. Well, a number of states have taken that on. In fact, if you look to the state to the north of us in Montana, the Supreme Court there, and in particular the Supreme Court Justice there, not only encouraged but authorized the release of all nonviolent offenders. And we have seen other actions either through the court system or through the executive branches of government and other communities. And I've heard anecdotally from my counterparts in those states a number of concerns. I also heard great concern from my county commissioners when I brought that topic up. And to this point, and although I have not heard from all of them and we haven't taken a formal position on any particular bill, but at this point, no commissioner has suggested to me that moving down the path of early release outside of our current system is warranted at this time. And in fact, I heard quite the opposite, that we need to do a better job of enforcing the initial sentences that are offered to inmates so that there isn't incentive for them to continue to commit crimes, understanding that those are going to be commuted through the process. The other major issue that I heard from commissioners across the state that I wanted to bring forward was discussion around the possibility of video arraignments and what that might do in our communities, not only for the health and safety of our public court system, but also for our inmates, reduced movement of inmates around communities, cutting down on the risk of spread of COVID as well as other things. I heard a great deal about Lincoln County that suggested that as much as 30% of their criminal system costs may decrease as a result of video arraignment and other electronic means of holding hearings and other parts of our system. They also shared that in their community that expense savings might also accrue to the state, given the fact that they also house a number of state inmates in their facilities at the county level. I also heard that from at least one county that you do have to balance this system out. You can't entirely move to electronic and video arraignments because there are certainly times and cases that warrant having criminals, maybe even the lowest level of criminals, come into a courtroom to be in person with a judge to hear the gravity of the situation and understand what they face, such that we could cut down on them becoming a recidivism case. So there is certainly interest in looking at video arraignments as part of this. No, Director Lampert shared with you some of the COVID-related costs that they've experienced. Certainly counties have had similar activities that have had to been undertaken. I can't give you numbers at this point in time. We've been waiting for state guidance on what would be allowable expenses under the CARES Act funding. The SLIB did approve rules this morning around that program, and so we'll be rapidly working with the counties in order to bring forward those not only existing expenses, but expected or anticipated expenses moving into the future. So I will have more clarity around that in the near future, but I don't have it today. With that, Mr. Chairman, I'd be happy to answer any questions that you might have from a commissioner perspective.
Representative Pelkey.
Thank you, Mr. Chairman. I guess I have a follow-up to a question that I asked Director Lambert. I was somewhat taken aback by news from my own county detention center that there wasn't any planned testing in the county detention facility until next month. We're talking July. And I really don't have any data on what kind of outbreak or no outbreak we're having in our county detention facility. And I'm just curious if you've got any data from your membership as to how they're addressing COVID, how they're addressing the question of testing, and then how they are addressing the question of a response in case of a positive test.
Mr. Riemann.
Mr. Chairman, Representative Pelkey, I apologize. I don't have an answer for you at this time. Perhaps my counterpart from the sheriffs and chiefs who will follow behind me with testimony could offer some perspective there from that angle.
Representative Pelkey.
Thank you, Mr. Chairman. If we can't get an answer on that today, could you do some follow-up and perhaps follow up with an email to us?
Mr. Chairman, I'd be happy to work on that.
Representative Gray.
Thank you, Mr. Chairman. Mr. Ryman, thank you for coming in. I appreciated what you said about the potential reductions on the video arraignment that could accrue to the state. It's always good when the association lays out those areas of potential reduction. We really need that feedback on reductions. So can you lay out a little more where we could reduce because of those savings and what exactly those savings are? Because that went pretty quick.
Mr. Riemann.
Mr. Chairman, Representative Gray, I'd love to give you more input. The particular county that information came to, it intended to testify and could have provided that. I apologize, I don't have it, but I can certainly dig further with them in terms of what that means across the system. Is that a state savings or is it simply a county savings that they could then use as part of their budget reduction?
Representative Gray.
Thank you, Mr. Chairman. I don't have anything further, sorry.
Representative Washington.
Thank you, Mr. Chairman. Mr. Riemann, it seemed to me early on in this COVID problem that one of the situations that became very evident early on was the lack of stockpiled reserves of personal protective equipment and other things. And as I understand, the basic plan is that there should be local reserves that will last for a certain number of days, at which point the state reserves should become available, which will last for a certain number of days, and then the federal reserves will become available. From the sense of the counties, how prepared do you think the counties were in terms of having stockpiles of personal protective equipment at the start of the COVID situation? And number two, what will it take to make sure that not just for contagious disease type situations, but for a wide array of emergency preparedness for the counties to be well situated? I know when money gets tight, it's hard to pay for things that are going to sit in a warehouse just in case we need them down the road. But I think when we have this COVID money, maybe this is the time to try and fund some of these stockpiles and emergency preparedness items that will be held in reserve just in case. I'd like to hear your comments.
Mr. Riemann.
Mr. Chairman, Representative Washut, I think you've hit on one of the most frustrating parts of this whole pandemic for counties and their emergency responders. Certainly counties, from what I have watched over the course of the last several months, had adequate stockpiles for a traditional public emergency. This was unlike anything that, of course, any of us have ever seen. And so those stockpiles quickly dwindled as we tried to support our community health systems across the state. We did receive some early shipments from the state, but as the state began to experience issues that the counties had in terms of getting additional equipment, either from the federal stockpiles or even from private vendors, things continued to accelerate in terms of the pain that was expressed at the local level, and that goes beyond just the personal protective equipment, but also the testing supplies or even the testing capabilities to get those reviewed. So I think that we are working, our emergency managers are working with the state to develop new protocols for stockpiles to ensure that we have additional equipment beyond those pieces that would typically be a part of that. And we are looking at should we and use some of the CARES Act funding to enhance some of our emergency planned responses in order to deal with these pandemics. I could go on about some other issues that counties experience, whether that be their ability to receive FEMA approval for the emergency management systems that they put in place, and getting approval from federal agencies to tap into those personnel. That became a difficult spot for a number of counties. Sublette County in particular spent several weeks trying to get additional personnel tasked to that, which came at the expense of our public health systems at the local level. So I do think that we want to see improvements in the system, and we have called for a review at the appropriate time of that entire emergency response system so that we can do better next time.
Representative Salazar.
Thank you, Mr. Chairman. Mr. Raymond, I have a general question for you. Some counties are dramatically cutting their budgets. Do you have any intent to come before the legislature if we do meet again in a special session for any help for the counties? Can you give me 30 seconds of your general thoughts on that issue? Thanks.
Mr. Riemann.
Mr. Chairman, Representative Salazar, of course, counties are going through the budget process right now, and of course, taking significant measures to reduce budgets. Your county in particular has been hard hit by this. Our association has done our best to try and provide them additional estimates of the revenue impact using some of the Craig data and our own models that we typically use. It's a dire situation. At this point in time, I think our approach is two-pronged. One, we're working with our national association, just like your body and the executive branch is, to receive some relief through federal aid, whether that's the existing CARES Act funding or some other pot of money in order to provide revenue relief at the local level. And second, to preserve that state aid that currently exists. I have not had discussions nor any requests from my members to seek additional state aid, understanding that the state has its own budgetary constraints moving forward, and we need to work alongside you and the executive branches. Some of those programs are cut or eliminated to ensure that can we continue to carry them forward? Do they need to be shut down their entirety? So I hope that helps to answer that question. But that's the work we're doing right now.
Representative Jennings.
Thank you, Mr. Chairman. I'll try and be quick with this. Mr. Ryman, if I understood you correctly, I want to take you back to the idea of legislating early release. Did I hear you say that your entire association, no one actually thought that that was the idea that we ought to be pursuing? Thank you, Mr. Chairman.
Mr. Chairman, Representative Jennings, I did put that question out to all my members. In the short time frame that I've had that question out there, I have not been able to establish an official association opinion on that. If a bill were to come forward, we will certainly do that. But at this time, in terms of the feedback that I did receive during that period of time, it was unanimous in opposition to that sort of approach.
Okay, any closing comments, Mr. Riemann?
No, thank you, Mr. Chairman. Thank you, committee. This is an important topic and I appreciate your time today.
Thank you for spending time with us. Mr. Odekoven, you would be next in line. We'll look for you to appear. There you are. Welcome. If you'd introduce yourself one more time and away you go.
Thank you, Mr. Chairman. Byron Odekoven, representing the Wyoming Association of Sheriffs and Chiefs of Police. Thank you to the committee for viewing this subject and taking the time this afternoon. I know we're running over, so I'll do my best to speed through some of my comments and touch on a couple of issues on the way by. First, I think I would like to offer our accolades as well to the director for the efforts that the Department of Corrections in exemplifying what attention to detail and hard work can do in this kind of a situation. And then offer that same hard work and attention to detail is what's going on at the county level. Because at the county level, our jails are a microcosm of the community as folks come and go. And for years, we've had to deal with hepatitis, AIDS, tuberculosis, and other diseases, and set out years ago on a practice called universal precautions, where we don't know what these people that come into the jail may have. Therefore, we treat them as if they may have some communicable disease until we find out otherwise. So we practice that cleansing, that do our medical screening, do our intake assessments, do our initial isolations until we can have some level of satisfaction that they are not contagious to the rest of the folks. Several of the jails have experienced an intake of a positive person and discovered it at the time that they were in intake. Did the medical isolation, put them into isolation, proceeded through the court process. Folks were released back out, and the public health then takes over on that vein. But while they were in jail, I'm unaware of anyone who was brought in that was contagious that then created someone else who was contagious. Having said that, we have a number of facilities that end up having their folks end up on the 14-day quarantine because they were exposed to the person, but they did not catch the virus as a result, is my point. We're burning through PPE at a faster rate than normal. Cleansing supplies are important. We're burning through that at a faster rate as well. It was disturbing a couple of weeks ago when we learned, and you posed the question of the state stockpile and the federal stockpile, we learned that on the federal side, law enforcement is considered a tier 3 entity. Therefore, in the priority of the federal stockpile, the detention centers are far down the list. So it will be incumbent upon local cities, towns, counties in the state to look for that PPE cleaning material and things to deal with within the environment, because we are down the list of priority from the federal stockpile level, is my understanding. There's again, a national discussion to change that, but that's the reality of where we are at the moment. At the question of early release and our discussion with the state pen in terms of, or the dialogue that we've had in terms of early release, I'm pretty sure my members would echo the county commissioners members of not being in favor of that, especially from the standpoint of if we remember where we were with the restorative justice or the criminal justice reform discussion, we've already reduced probation time, we've already reduced pen time, we've already reduced several things. In fact, we had to scratch back a little bit just because we recognized that some of those early release dates actually came before they were able to finish their programming or counseling or treatment modality that was prescribed for them in the detention setting. And it looked like we were going to release them before they actually finished back to the community. So one of the things that we're discussing is what is appropriate level of treatment and how will these budget shortfalls impact treatment? And if we do less treatment, how do we ensure that folks, our inmates, are coming back to our communities in a rehabilitative form? You know, are they coming back ready to lead a law-abiding life, or are they coming back after a certain hiatus from being in the community? So something to consider going forward of ensuring that we are providing that proper programming and that proper treatment for folks in the corrections setting to ensure when they return to our community, they're leading a law-abiding life. It will be interesting to see what the director noted, that they're doing reduced number of drug screening. That word's out, I might add, on the street. We're seeing some of the impact of that in the folks that we're dealing with. It's clear they know their likelihood of having a drug test is down, and they're exhibiting some of those behaviors. So it'll be interesting to see what happens when drug testing picks up and resumes again. I sense we'll have quite a bit more data on what people did when they weren't being tested. I think that will impact our recidivism rate, unfortunately, and will have a bearing on part of this discussion of if we don't follow through with our side of the house, so to speak, what impact that has on the inmates as they're either inside the program and once they're released. We are concerned about the, as I said, the programming and treatment and where we are with our budget reductions, both at the local level on what the state has asked local counties and communities to pick up the pace, if you will, on providing some of that local programming and local treatment. I'm nervous for the budget reductions in those areas, and I anticipate that an overall discussion of priority of services and will be a dramatic discussion to have, depending upon how far the budget cuts go. And I'll pause with that, Mr. Chairman, for a second, and then a couple more points.
There's a question from the good barrister of House District 45.
Good barrister. Thank you, Mr. Chairman. You know, you may have heard me allude to a concern I had about testing in Albany County, that there were no immediate plans to do testing of inmates until next month, or at least large scale testing of inmates until next month. I don't know if there even been individual tests. And I'm just wondering if your organization has a set policy or a recommendation for those members who are in charge of detention facilities in the counties. You did say that you were pleased with the Department of Corrections and that you felt that those efforts were being mirrored at the county level. But if you could quantify that, or at least give me some description of what policies are in place to make sure that inmates and detention center employees are kept safe.
Mr. Odekobe.
Thank you, Mr. Chairman. Let me kind of a two-part question. Let me take the first part dealing with the inmates. As I say, we're kind of at the microcosm of the general community. So in terms of testing, each of the facilities has access to medical personnel, nurses, whether on staff or on call, doctors on call, physicians assistants coming medical rounds, doctor visits, all of those kinds of activities take place, and then are coordinated with the public health and the public health nurse. So we would be representative of reporting that information out. And if the public health authority doesn't view that we need to go and do testing based on having cases come up, no different than we wouldn't pick a neighborhood out of a city and say we need to go test all of those folks in that neighborhood as well. So I think relying on our local medical processes, relying on our local medical authority to make that determination and to ask as well for the testing.
Representative Pelkey.
I appreciate it. We've had a couple of months of this situation going on. Do you know if any of us in the legislature and the public can get access to data about what steps have been taken so far? Personally, would like to see a breakdown of what steps have been taken by all 23 county detention centers, and if we have any data in terms of positive tests and number of tests conducted, number of negatives, et cetera, et cetera.
Mr. Odakoven.
Mr. Chairman, I'm unaware of a specific breakdown within a detention setting. Each of the 23 counties, if there were a positive test, would be listed on that county's data set reported to the state and on. In terms of medical protocol, if you're asking about what the medical protocols are, those have been in place for years. That's fairly well described in the universal precautions and what is being done. I can certainly provide you with some idea and detail as to what that entails.
Okay. Representative Washit.
Thank you, Mr. Chairman. Mr. Odakoven. Two questions, actually. The first one is, here in Natrona County, the Emergency Management Office is located in the Sheriff's Department. Is that a universal approach? Do all the counties do it that way? And my second question would be, after several weeks now in this COVID environment, have there been any efficiencies identified by the chiefs and sheriffs that, you know, previously we did things one way, we did them differently during this COVID environment, and that maybe when COVID is all over, we're going to continue doing some of these things the way we did during the COVID time. I know in our county, the number of arrests are down, the number of traffic enforcements are down. Maybe that's a good thing, maybe it's not. Comments from the chiefs and sheriffs.
Mr. Odakoven.
Thank you, Mr. Chairman. The first part of that is lessons learned, if you will, or procedures that may fit. I think our discussion this morning on telemedicine, telehealth, and then we carried on to video arraignments, the interaction, the transportation back and forth. It was mentioned Lincoln County, the distance between the two major population centers in Lincoln County, just transporting back and forth, indicate that video style delivery of all three of those topics would cut down on transportation costs. So depending upon what the accepted practice post-COVID is, in those three areas for sure, there would be some considerable savings. There's some expense to go in to upgrade on equipment that wasn't anticipated to have at this level. And then the long-term savings, I think, would be rather significant. In terms of your second one, remind me, you were asking about the
emergency management. Is
Thank
it
you.
located in the sheriff's office everywhere?
Thank you, Mr. Chairman. And it is not. In many counties, it is within the sheriff's office. If it's not within the sheriff's office, it's usually part of the county commissioners or under the county commissioner's umbrella, if you will. A lot of them are then located back to the sheriff's office, however, or in a separate county facility, as far as I know.
All caught up? Anything in closing, Mr. Odakoven?
Mr. Chairman, quickly, I think there was a comment earlier on Laramie County serving writs, and there was a discussion of not, or civil process or law enforcement sheriff's offices suspending civil process. So as an update, I fired that question off after that comment was made and received some quick responses back. And I think for the most part, the word is it's business as usual for the usual business that we have. In that when the pandemic first started and the health officers limited activity, many of the sheriff's offices and the courthouses closed. Thus, we were not doing activity in the lobby, VIN checks, fingerprints, a host of activities. And I'm aware in at least 2 counties, and Laramie County being one, where they suspended doing most of the civil process, except for the most serious, in order to limit some of that person-to-person contact. Same with the courts. The courts aren't issuing some of that civil process either, because they aren't having the court case to have that civil process issued. The particular case that was cited, the one eviction, the eviction notice was issued, was not served timely. The folks sought a relief from the court prior to there being a court case. That eviction notice was served, the case was dismissed. So the sheriff did not go to court in that particular case. The matter was dealt with before that came out to be. Other comment in terms of, I think I want to again echo a job well done by the detention centers and law enforcement. When a lot of people were doing the telecommute, if you will, work from home, officers are still on the street answering calls, 911 rings, we still go. That is business as usual. We were not successful in our attempt to communicate to the criminal folks that we're in a pandemic and they're supposed to stay home and lead a law-abiding life. That didn't seem to quite, that message didn't quite resonate. I think by staying home, we did end up with considerably less traffic, considerably less foot traffic out and about. So I think that accounts for a lot of our reduction in case and call load and inmate detention in the detention centers. Mr. Chairman.
Thank you, Mr. Oderkoven. We too appreciate that work done all over the state on the local level. Madam Co-Chairman.
Thank you, Mr. Co-Chair. Mr. Oderkoven, does law enforcement need PPE since they're a tier 3 on the federal receipt?
Mr. Oderkoven.
Thank you, Mr. Chairman. Thank you. Yes, Madam Chair, we do. In fact, I'm fielding questions regularly back out to the national sheriff specifically, who are making requests of the White House to have that moved up. As you know, some of our PPE was redirected early. It was destined for the state of Wyoming and went to other places. So our allocation from the federal stockpile was reduced. I don't sense that we've caught back up with that. And in the long term, yes, PPE, disinfectant, hand sanitizer, gowns, masks, shields, et cetera, will be of even greater urgency if any of the modeling predictions for later this winter come to about.
And Mr. Co-Chairman, follow up.
Yes.
Are the counties or sheriffs and chiefs, anybody working with the governor's office to get that PPE and making a greater priority? I mean, it is a microcosm of the greater community, and I think probably the population you see first may be more likely to get it first. And so, any thoughts about any progress there with the governor's office? Anything that the legislature can do specifically on this front as it relates to getting you the right equipment for cities and counties?
Mr. Oderkoven.
Thank you, Mr. Chairman. So our process works that we make the request, the sheriff or the chief makes the correct request to the local health officer then passes that up to the state level, and that is then prioritized within the state system under the direction of the state health officer. So I don't have the number in front of you as to how far we are in the state process now. According to the last call I was on Wednesday, they're making additional shipments this week. So I'm unaware of the actual percentage, and perhaps Mr. Riemann may have a better answer from the county perspective than I do from the requesting.
Mr. Riemann, did you want to contribute?
Yeah, Mr. Chairman, if I could, Co-Chairman Ellicott, just quickly on that, all of the emergency management personnel at the local level have, I believe, a twice weekly call, which includes the governor's office, the Department of Homeland Security, and the Department of Health. And so I do think at the state level, things have ironed out. Over the court, our association hosts thrice weekly meetings with all of those groups, and this issue has not been a topic of concern for several weeks. So I do believe that we're at a point where stockpiles are rebuilding. We're not getting bumped, as Mr. Odakoven mentioned. A number of orders that both the state and counties had in to the federal stockpile and to private vendors were jumped. We got bumped out of that by the federal government in particular. So, but that's an issue that hasn't been there for several weeks. So I do think we're in a good place right now.
Madam Co-Chairman? Looks like we're all good then. Okay, thank you, gentlemen.
Thank you, Mr. Chairman.
We have one more witness. We have County Attorney Trent. And if you want to turn on your camera and join us. There you are. Here's your chance to end your day with the Judiciary Committee. What could be better than that? So,
thank you very much. Thank you, Mr. Chairman and committee members. I wanted to touch upon a few items that have been discussed by the Department of Corrections as it relates to early release of inmates. And I'm speaking today as the Albany County prosecuting attorney. I have not spoke with everyone in our communities throughout the state, but I wanted you to be aware that there were some positives that came out of this COVID and prosecution. And a lot of it, I'm going to give credit to the criminal justice reform that you had put in place over the past 2 years. In Albany County, we actually became more familiar and utilizing the tools you had provided us as a prosecutor as we went through the process of these uncertain times with the COVID. In Albany County, we made utilization more often of no pre-sentence investigation, of sentencing directly and unsupervised probation because of the uncertainty as what was going on. So we found, at least in Albany County, the tools you had put in place actually helped us to get through the crisis and the pandemic that we were faced in our criminal justice system. When I hear the Department of Corrections wanting to pursue outlining the 5 areas of early release of inmates and wanting to consider something of legislation under Title 19, that when you declare a public health emergency, that we empty out our prisons and or home confinement as a step down is very alarming to me as a prosecutor as I move forward, because when we were in a pandemic, what I've learned is keeping people present that are there long term. The issue becomes the in and out at the local level of inmates coming in and out and being able to step. As a result of legislation you put in place over the past years, we did more split sentences. So those individuals that were in the jail, we were able to keep in our county jail not entering them into that system so that you're entering more opportunities for the spread of that virus. So I would respectfully disagree that there needs to be a jump or a leap right now to new legislation when you've been thoughtfully going through the process of how do we change our criminal justice reform, that we're looking more to more processes. If anything, what has been highlighted to me in Albany County is a need for a pre-trial release program. And why is that important? Is I think Representative Pelkey will attest, I literally emptied our jail because we didn't know, and we wanted to keep the people who were there under split sentences and our violent criminals. But now I'm faced with a really major problem as a prosecutor in Albany County as a result of what we did. We are now revoking bonds. I can't even tell you the number of bond revocations I'm going through right now. I'm going through during that time period. We were also terminating probation early. We were reducing that item. And what we were putting more our resources to is to how to keep people out on bond, not committing violent crimes. And we have an increase right now in domestic violence and mental health and what was going on with our Title 25. As a matter of fact, I was presented with the most unique, if you hadn't heard about it on the news, the processes we use in Albany County of keeping our youth out of the detention center. We're fortunate in that regard. We don't have a juvenile detention center. We had nowhere to go with our juveniles. And by emptying our jail, that opened an opportunity for a pod that if I needed to find a location for juveniles, and I still have this issue today. We then realized quickly we needed ankle monitors. We need legislation to support us to put them out in that pre-trial release program, whether that's ankle monitors, supervision, and moving the dynamics and changing of what we're doing with inmates. That's what was really highlighted to me as a prosecutor in my community of what we see needed. I've stood before you at the last legislative session respectfully requesting pre-trial diversion, pre-trial programming. Unfortunately, we were in a budget session. Unfortunately, that wasn't the time. But if anything, we have seen through COVID and the times we went how necessary this programming is to our operations. If we have another wave of COVID, how does that look in my community? And I need to take advantage of that pre-trial release programs, of ankle monitors, of supervision, of tools that are available to me in order to keep the system flowing. Many communities, not including myself and other communities, we thoughtfully went through the process of how to release inmates out of our jail and how we were able to utilize that space in the event we needed it and what we have. And unspoken in all of your communications today is Title 25. And I know we don't want to bring that up. That's a whole separate 5 hours to discuss. But what's alarming to me is I had basically a catch and release program going on right now of mentally ill in our community because of that COVID and that spread of it coming in and out, and how do we handle it? These are dialogues, I think, not for before 5 o'clock today, but something we need to look into as we move forward now in our discussions. But I thank you personally for what you've done in criminal justice reform. It made me learn more how to use it, how to become creative, how to utilize all the tools that you provided me. So I'm appreciative of what you've done, but we need to go further in having these dialogues on criminal justice reform and how we can take it a step further so that when we get in these times, and we will be here again, we're prepared in a different manner. Thank you, Mr. Chairman and Co-Chairman.
Thank you, Ms. Trent. Always good to hear from you. Any questions or response to Ms. Trent's testimony? Committee, anything? All right. Thank you, Ms. Trent. Committee, I'm not aware of any more public comment today. So I'll bring these matters before the committee and see if there's any actions you want to propose. Representative Pelkey. Representative Pelkey, your mic.
Yeah, my lips were moving and nobody could hear me. I'd like to make a motion, not for a recommendation for legislation, but for a request for information. If LSO could coordinate with the county commissioners and the sheriffs and chiefs of police to get some actual hard data for the committee on testing and COVID results. We got great data apparently from the Department of Corrections. What I'd like to do is get a breakdown on county by county. So I'd like to make a motion to direct LSO to try and acquire that data between now and our next meeting, if that's possible.
Second.
Seconded by Burlingame. Any discussion on that proposal by Representative Pelkey? Representative Burlingame?
Mr. Chairman, I think that's a great place to start. I mean, I went into this meeting believing that we would direct LSO to look at an early release program. I don't think there is any, I don't think there's any justification for saving folks from exposure to COVID-19 when there is zero COVID-19 within the prisons. So the next logical place to me looks to be exactly what my good colleague, the honored barrister, I forgot what we're calling him now, suggested, and just get a little bit more data on that.
Okay, Madam Co-Chairman.
Yeah, thank you, Mr. Co-Chairman. And I support the desire for more data. Would it be satisfactory to, I know Mr. Riemann is listening and so is Mr. Odekoven. They're pretty solid in coming forth with information and coming and attending all of our meetings. But if we requested just directly them, this committee through this meeting, instead of having LSO do another task right now, if that would be satisfactory and they provide it in written format in a way that we can read, digest, and understand. Just a suggestion if that would be an acceptable alternative and reduce LSO's load.
Representative Pelkey.
I would view that as a friendly amendment. The only thing I'd ask is that we get a comprehensive look from both organizations, that they could compile data that would include all 23 counties in Wyoming. Again, I was taken aback by the lack of plan to do any coordinated testing in Albany County until next month. And I just like to get the data from around the state. If I can get it from those two organizations without LSO interceding, I would regard that as a friendly amendment from my good colleague and 2009 classmate.
Okay. And Representative Burlingame, you still had a blue hand up? You're good. Okay, does that even require a vote, or are we just asking LSO to communicate with those people and ask for those materials? Madam Co-Chairman, do you have a thought on that?
Yeah, I think that's fine. I just want to kind of be clear that our expectation of LSO is not to create the document or have to analyze the data and make us another memo or a chart or a PowerPoint. And really that work is the responsibility of Mr. Riemann and Mr. Odekoven, who will then get it to LSO. And they're just the recipients of the work product created by Mr. Riemann and Mr. Odekoven.
Okay. Representative Pennell.
Thank you, Mr. Chairman. Along those same lines, I'm curious if they would want to bring us more data as far as cost savings on the arraignments, video arraignments and so forth. I know we had discussion on that earlier. So I don't know if that would be a time that they could bring that forward on the cost saving, if we were to look at the variety of counties out there that don't have that ability to do those video arraignments and so forth, where it would save the cost of transportation and safety.
Okay. Representative Pelkey.
So I will amend my motion to just say Judiciary Committee says get to work, go to COVID.
Okay. Couple of blue hands are still up, but I think you gentlemen have just spoken, so I won't call on you again unless they continue to be up. Representative Washit.
Thank you, Mr. Chairman. I think it would be a good idea, and I'd ask the LSO to do a bill draft allocating funding for the jail and court video systems. And we can fill in the dollar amount after we get some reports back. But I'd like to have that prepared, and then we can talk about the detailed dollar amount once we get the figures from the various entities.
Second.
Moved by Washit, seconded by Pelkey. Any discussion on that motion? Any discussion? Representative Gray? Is that a hand?
Thank you, Mr. Chairman. Yeah. I'm not comfortable going this direction yet. I mean, I think that we didn't get a report on what the potential savings are, what the court system needs. I mean, I know this is our first meeting, but I mean, I just think that what's going to come out of this is just a list of more expenditure without any of the accompanying efficiencies in that piece. And it amazes me in this legislature, the inability when an expense is incurred to have the supposed reduction that is going to come on the back end be paired in that bill, because all I hear about are these investments and et cetera, and we never get the reduction. And then it happens, the investment happens, the equipment's put in, and we never get the reduction. Never happens, ever. And I really think we got to go through the right process here. Suppose once in a while it comes through appropriations, but I haven't seen it in a standing committee bill that I've ever worked with. And we tried to do it earlier today, tried to put together a conceptual amendment, but I'm just not comfortable with this right now with where we are. And I don't think it's been thoroughly enough vetted to yet hit a bill draft. So. Because we don't have what the efficiencies are. I mean, it's a key part of the whole question.
Back to Representative Washit.
Thank you, Mr. Chairman. I think some of the efficiencies are just apparent, just obvious, that when we have 20 inmates awaiting arraignment and they can be seen one after another from inside the detention facility without loading them in a van and driving them to the courthouse and monitoring them throughout the entire legal process and putting them back in the van, driving them back to the jail, searching them, reintroducing them to the population. There are obvious efficiencies built in. Now, whether that equates into hard dollars, it ought to, and there's nothing that would prevent us from adding an amendment to the bill draft after we get some more data to call upon these efficiencies. And I share a good representative from across town's point of view that everybody promises if we do this, it will make government less expensive. And then, well, we need to keep those savings within the department and so forth. Well, I think there's going to be ample budget cuts, quite frankly. I think we're going to have cuts more than we've ever envisioned in the coming weeks, just because of the reality of where we're at. So I just think it's a good idea to get the bill drafts in place. We can amend them with efficiency requirements and so forth and savings requirements at the next meeting. But just, we work under a tight time frame here. I think it'd be nice to have the bill draft done.
Okay, let's go to Pelkey and then back to Gray. Representative.
Thank you, Mr. Chairman. I find myself in agreement with Representative Washit. The request for a bill draft is the first step. we will be asking for data. We will be looking at where those cost savings can occur. And if it becomes evident that the savings are not going to even come close to matching the expenditure, we can discuss that, debate it, and vote on it. But at least we can get the ball rolling with this, with Representative Washet's motion. So I would urge my colleagues on the committee to vote in favor of this.
Representative Gray.
Thank you, Mr. Chairman. Yeah, I'm going to be voting no on this. I mean, I think there could have been a good conceptual bill draft, but we didn't get a list. I mean, we're just basically saying, okay, LSO is going to communicate with the judiciary about, I mean, I guess we're just going to do everything is the bill draft motion. And the efficiencies aren't obvious. I mean, like in the other conceptual bill draft from this morning, we got specifics from the agency director on what the travel costs were. And I tried to plug that into a midpoint and try to build that efficiency into the bill. And I'm just not seeing any of that analysis here on this one. And so I just, it's not enough for me. I would be voting no, but thank you.
Representative Washet.
My error, I didn't take the blue hand out.
Representative Pelkey.
And I am merely calling for the question.
Okay. Question's been called for. All in favor of Representative's motion, please indicate that by raising your hand up by your face. 3, 4, 5. I believe I have 9 ayes. All those opposed, please raise your hand up by your face. 1, 2, 3. I count 3 noes. So the motion is carried. Any further suggestions for a bill draft or on this topic? Okay, Representative Washet, you talked at lunchtime about wanting to circle back. Was that it, or did you have something else in mind regarding funding for jail technology?
Mr. Chairman, that's pretty much it. I just think that there's some efficiencies here, and it's not often that the world gives us a social science experiment to learn from. And COVID-19 really has been a social experiment. We've learned some things from it, and we've had judges who historically have been reluctant to do video arraignments across the state, even though the sheriffs were saying, look, it takes a lot of manpower to move inmates from the jail to the courthouse and back. And that's a labor demanding process. And now, because of COVID-19, we've got judges on board saying, you know what, this is a pretty good idea. And if it takes a little bit of money in order to use some of this CARES Act money to build the infrastructure to make this all possible, I think we're well ahead in the game.
Representative Pennell.
Yes, thank you, Mr. Chairman. I'm still going to want to know what, and hopefully the commissioners and the Sheriffs and Chiefs Association will still have answers as far as how many departments currently can do this, how many court facilities can do this, because I'm looking at the numbers. So I hopefully they'll have that available when we do meet next time. Thank you.
Okay, Representative. And we'll task LSO with communicating that to the commissioners. Is there anything else we need to discuss to wrap up this last topic? Anything else? If you don't come up with something in the next 30 seconds, we're going to go to LSO and kind of get a summary of what we've done today and what we've charged them with. So I don't see any other blue hands. Mr. Fuller, you have a summary for us?
Mr. Chairman, here's what I have from the meeting today. A request for a bill draft for the Department of Corrections for $95,000 of CARES Act funding for specified telehealth equipment. A bill draft for changes to 35-4-114 based on language that Representative Stiff provided that was altered from what what Mr. Cave had earlier provided. A bill draft for amendments to 35-4-109. A working group consisting of Representatives Pelkey and Burlingame and Pennell and Senator Anselmi Dalton to work on an immunity, and Chairman Nethercott to work on another bill regarding immunity. A bill draft that would resurrect 2019 House Bill 105, which is the limitation on municipal services pursuing property owners. And a bill draft to amend Senate File 1002 to explicitly make clear that landlords can apply for funding under that established program. A request of the Wyoming County Commissioners Association and the Sheriffs and Chiefs of Police Association for data on all 23 counties regarding their detention facilities and COVID. And then finally, a bill draft for funding for jail and court video systems.
Right, thank you, Mr. Fuller. Any corrections to that, committee? And put an asterisk by the one where you're requesting information of the commissioners and the chiefs of police, sheriffs, that Madam Co-Chairman will be upset with you if you take that on yourself, other than to send them a simple 3-line request in an email.
We can, Mr. Chairman, we can certainly abide by that.
Yes. Okay, let me, Madam Co-Chairman, we'll go to you in a couple of moments here. My summary comments would be that we've scheduled a June 19th meeting, in theory, a morning meeting to review these bill drafts that we've put together and that LSO is going to be working on. We've received some suggestions from leadership in the legislature that when we get to the special session, you know, if every committee brought 6 bills, there'd be a lot of bills to hear from in 5 days. So I'm not sure that all these ideas will get processed at that time, even if they make it through our June 19th meeting. Some of them may be good ideas that have to be put on hold till a later time, but anyway, they're still good ideas and we'll see where they get to. That's what I had, Madam Co-Chairman.
Thank you, Mr. Co-Chairman. Yeah, those are just my concerns from today too. I think we did good work today, but I do think leadership and the legislature might be frustrated with the Judiciary Committee if we bring forth a great number of bills, which it would be 6 into this 5-day special session or less. So we'll just need to be mindful of that for June 19th. You know, one piece, and I don't want to. I almost said it then, and I'm not certainly indicating it now, but the criminal piece associated with smallpox, I'm not certain that that's a primary concern right now for the June special session meeting. So maybe that one we can flip over into our regular interim work as opposed to bringing that bill forward for the whole legislature to review. And that's just kind of a starting place, but I'll leave that up to the committee to decide. But for our next meeting, we gotta be lean and mean if we're gonna not do 1 a.m. special session warnings. So those are my comments, and I think we did a lot of great work today and covered a lot of ground.
Okay, anything else, committee, before we adjourn? Thank you for your attention and hard work, and have a good couple of weeks until we see you again on the 19th. Meeting adjourned.